Item 1, no instruction match.
Dismiss for non-prosecution.
Weekly list old matter item number 2.
No instruction, my lord.
Dismiss for non-prosecution.
Weekly list old matter item number 3.
That's item number 3, my lords. Okay. That's item number 3 is relating to, my lords, lease of this Bharwati Stadium area, my lords. May I, my lords, straightway take
In
it.
fact, before my learned friend starts here, this is a matter where I was specially engaged by the state to argue on behalf of the state. This 2014-15. Meanwhile, the erstwhile Learned Advocate General issued a letter that the special engagements in favor of, at that point of time, be returned back to them. I have written a letter to the state to take back the file from me and engage their counsel. They have not responded till date. Not the file.
No, you're for whom, sir?
For the state.
For the state.
He was appearing for the state as a special counsel in the year 2010.
Now you are there.
Now we
So
are
that is
there.
what I am requesting, Lord.
Now the
But
case
you may
can be
kindly
heard.
note that I do not intend to appear here as a special
All
engagements
right.
counsel.
That
Let
can,
them take care of their matter. Either the state should take steps to take back the file from me, or because the original file is with me.
let him give the file before your lordship. I will receive it as a state counsel. I can receive the
Mr.
file.
P.K. Ratha states that since he's no longer appearing for the state, he will be returning the files to Mr. D.K. Mann, Learned Additional Committee.
My lords, the thing is that, my lords, these lands were part of Khasmal estate, my lords.
All right.
Well, so Khasmal estates were earlier, my lords, governed by Bengal rule, Bengal regulation during British regime. Subsequently, my lords, Bihar, Orissa, my lords, estate manual.
Right.
But what happened? The Olympic Association was allotted that land for the construction of the stadium, wherever the stadium situates. And for the purpose, the lease period expired. Thereafter, they applied for renewal of the lease. Also, in the meanwhile, a development occasion, my lords, under the Odisha Government Land Settlement Act, amendment was carried on, and all these matters were included within the provision of the Odisha Government Land Settlement Act. Khasmal, Nujul, Gramkot, and Parambhog. All those lands were included, and there was a provision for permanent settlement. Accordingly, Tahsildar initiated the proceeding. Matters recommended for a settlement of that land. Collector confirmed it. Subsequently, the divisional authority, means RDC, he reversed it. That is in annexure, kind of a glance to annex page 20, 25. It starts from page 25.
Yeah.
Now, stateway matters, kind of a glance to matters, that order matters, the region for interference, that is at page 27. May I read matters?
Yes.
1. Provision of OGLS Amendment Act 90, OGLS Amendment Rule 1993 do not provide for permanent settlement of Khasmal land either other than those as homestead in urban areas. Well, then the second, Khasmal land used for the purpose other than homestead in urban areas shall be deemed to have been leased out under the OGLS Act in favor of the person holding such land as lessee and sublessee. The land in question being the land other than the homestead should have been recorded in favor of the respondent as a lessee after completing the formalities as per the OGLS rule. Thereafter, the RTC referred to number of irregularities in connection with the procedural formalities. Now, the law has got changed. It's kind of a glance to OGLS Act, Amendment Act in the edition of 2009. Yes. Subsection 4, section 3, my lords.
Yes.
May I read, my lords? Subsection 4, section 3. Notwithstanding anything to the contrary contained in the preceding subsection or in any other law or any custom, practice or usage having in force of law, any land of the category of Khasmal, Nujulu, Gramkant, Parambhog, or Abadi, wherever situated and used for any purpose, may on application be permanently settled with heritable and transferable right with the person who is in occupation of such land, either on the basis of the lease or otherwise, for a period of at least 3 years prior to the appointed date, in such manner, subject to payment of such amount to the government as may be prescribed. Thing is that Now, irrespective of the land use, this can be settled. Pursuant to that, my lords, the government made a, my lords, instruction. My lords, I have one copy of the instruction. Sorry, my lords, I don't have a copy of that instruction, but one copy I do have, my lords, for my lords perusal.
No, but have you applied under this amended provision?
No,
No,
there is
he
no
has to
necessity.
make an, yes, he has to make an application
No,
afresh
may I submit?
under this amended.
Just a minute, may I submit? These regulations, rules, government, the instruction government made, my lords, their government has specifically said the application which are pending, this should be considered in accordance with the new rule. Now, in view of this, my lords, setting aside of the order, my application continues, my other application is pending. That would be dealt with in accordance with the new rule. If necessary, I can file an application.
Yes, that is
But fact
better.
remains, well, so now in view of the fact that well, kind of a glance to this miscellaneous provision, provided that if any such application, that is in application pending.
Where are you reading, sir? What are you
But
reading?
here in this case, my lords, revisional authority set aside the settlement. But the application remained with Tahsildar. Now Tahsildar is to begin afresh. Tahsildar is to act upon that application.
Since it is already set aside by the revisional authority, what I
No, no,
Why did you
let
make a
him,
fresh application?
let him make a fresh
My lords,
application.
grant me, my lords, permission.
All right.
Yes, that permission is
Grant me, my lords, permission to apply for that.
under the new amended
We'll give a
provision.
time bound thing. The status quo will continue till then.
My lords.
Yes, madam. Yes.
We say in view of the amendment, the section 3(4) of the Orissa Government Land Settlement Act 1962 (OGLS Act), with effect from 26th February 2009, Mr. Dayananda Mahapatra, learned counsel for the petitioner, states that the petitioner will make a fresh application for settlement of the land in question in its favor by complying with all the requirements in that regard. If such application is made not later than 1 month is enough.
1 month is enough.
12th September 2022. Then, notwithstanding the earlier rejection, the impugned order of the revisional authority, reversing the order of the Tahsildar settling the land in favor of the petitioner, and an independent view will be taken of the said application in light of the amended section 3(4) of the OGLS Act by the authority. Who is the authority? Who is to,
Tahsildar.
Tahsildar.
by the Tahsildar. By the Tahsildar, after hearing the petitioner, and a reasoned order shall be passed on such application within a period of 3 months thereafter, and in any event not later than 19th December 2022. The court clarifies it has not expressed any view in the matter. Till such time, the status quo order passed by this court in the present petition on 4th December 2002 shall continue. The petition is disposed of the above terms.
Vehicle list item number 4.
Lord, I appear for the respondent 1 and 2 in this matter, my lord. This is a matter in which the petitioner, through a public interest litigation, my lord, questioned the power of a national generator, namely NTPC.
Anyway, nobody is
No,
appearing for the
petitioner is
petitioner.
not there.
Yeah.
I am for opposite party number 4.
No,
All right. None appears for the petitioner. Dismissal not possible.
Obliged. Vehicle list item number 5.
Item number 5, the file has transferred, my lord.
All right. Counsel, the petitioner states that the file has been transferred from him. None appears for the petition.
Vehicle list item number 6.
None appears. Dismissal not possible.
Vehicle list item number 7.
No instruction, my lord.
No instruction. Dismissal not possible.
Vehicle list item number 8.
May please, Your Lordship. Lordship, petitioner the purchaser, leave was granted in 74, Lordship, and leave was cancelled in 1998, Lordship.
When was the date of the purchase, sir?
11/6/1982, Lordship.
All right. Counsel, the petitioner points out that petitioner purchased the land in question by a registered
14 years.
CT on 11th June 1982, whereas the impugned order was passed by the Additional District Magistrate bracket AD bracket Bhubaneswar in revision case number 846 of 1998 on 28 July 1998, cancelling the lease granted in favor of the petitioner's vendor. Stop. Admittedly, such order was passed without notice to the present petitioner. Stop. Paragraph on the above short ground. The impugned order dated 28 July 1998 of the ADM. Bhubaneswar is hereby set aside, and revision case number 846 of 1998 is restored to the file the ADM, where it will be listed on 26 September 2022. The petitioner will appear before the ADM on that date, along with a downloaded copy of this order. The ADM is requested to proceed with the revision case and dispose it off in accordance with law after hearing the petitioner within a period of 4 months thereafter. The petition is disposed of.
Weekly list item number 9.
My lord, I am appearing for ITCO, my lord, in this case.
None appears for the petition. This was not possible.
Weekly list item number 10.
Much of it.
My lord, here the petitioners are 15 in numbers.
Yes.
They are landless persons, my lord.
Yes.
Since 1967, yearly lease has been granted to these petitioners for agricultural purpose. The land is, my lord, riverbed, my lord. Because they have not renewed the lease, for which, my lord, I have filed the writ application. And by the order dated 14/8/2018, this Honorable Court has directed the Council for the State to produce the lease case number 20 of 210 of 1990, my lord.
Yes. What's the
That counter affidavit has been filed, but
Because they have disputed that the lease has not been granted to us. That's why, my lord, this Honorable Court has directed to produce that lease case, my lord.
the lease case record is not available in my the old order. Let me get that lease case if your lordship, or your lordship may remind it to the Tahsildar to verify all these things, and if it is
They are all landless person, my lord. They are, my lord, their
But
only livelihood is, my lord, that from
no,
the,
so
that.
is there a status quo order passed here?
yes,
Yes, my lord.
So that continue will give a time bound direction to the task.
My lord, in this matter, I have filed for the interveners. My lord, for
Their
all the
claim has been
for all the villagers.
Kindly bear with me. Their claim has been rejected by this Honorable Court by the learned single judge, my lord.
No, not rejected. It was directed for the Tahsildar to consider. They had also filed one rate application saying before the single judge. It was directed. Your lordship may director, I would be hard there. In single judge matter, my lord, it was directed that I would be hard. All the interest, 60 numbers of villagers, my lord, their lease has been granted in their favor. Your lordship
Not a single scrap of paper they have filed for which this Honorable Court has rejected their claim.
You have not served the copy of the writ application. Whatever material was available, I have filed 1952 of 19. Along with them, my lord, 60 number of villagers, we may be hard.
No
We
harm
may be
in
hard,
hearing
my
them. Let them be heard.
My lord,
Yes.
we are the leaseholder.
It's all right. Let them be heard. If they have any claim, let them seek to establish it. We say it has been agreed by the parties that the petitioners should be heard once again for the Tahsildar. Of which place is this?
Astarango, my lord.
Astaranga.
Astaranga.
Village Astarango.
Notwithstanding the order passed on by the Tahsildar, on which is the date of the order of the Tahsildar?
My lord, lease was granted in 67, 68, that is Annexure 1.
No, the order, the Annexure 3.
Annexure 3. Oh, order tak pass kari.
My lord, I have prayed to extend the lease, my lord.
No, what is the order? That 3/11/77.
No order has been
My
passed.
lord, since annexure was in 1967, the lease was granted. It was extended yearly. And the order was under annexure 3 is dated.
My lord, they want that the lease should be extended. Counter is there. They are relying upon some forged document. They are knowing that is the counter.
Yes, yes.
That's why, my lord, this honorable court has directed to produce that lease
Maybe,
case.
yes, that may be the fact. Because the specific counter affidavit filed by the Tahsildar, whatever document they are relying upon, all are fabricated documents.
Your lordship may kindly hold that in lease case number, which the record will directed to be produced. They will see that lease case, my lord, lease case number 210 of 90, my lord.
May I suggest one thing to your lordship?
Yes.
Your lordship may direct the sub-collector. He is the authority, sub-collector Puri. He will examine this and pass a necessary order whether the petitioners are entitled for extension of the lease period or not, taking into consideration all the materials and after hearing the objectors.
All right.
One more prayer before your lordship. Well, pursuant to the direction of the honorable single judge, well, Tahsildar must not have dispute of the matter. All the matters may be examined by the sub-collector.
That has been rejected. They have challenged that. This honorable court has rejected their claim. My lord, I was appearing in that case.
Where is the order? Just show us.
Order, my lord, I have not brought. That is my lord, writ petition number.
Better that sub-collector should deal with this matter because Tahsildar is a party here. Sub-collector should hear both the parties and examine all the records and pass a final order whether the lease is liable to be extended or not. That is the prayer, I think, of the petitioners.
My lord, they will take into note the lease case number 210 of 90.
Considering all the materials, all the previous lease case records, everything. Because there is no impugned order. What I beg to submit before, there is no impugned order as to why they are not extending. So that firstly, that has to be adjudicated and an order should be passed. Then only somebody can be aggrieved with that and file a writ petition.
Okay, the 50 petitioners who are residents of Astaranga and District Puri have approached this court for a prayer, for a direction to the opposite parties, state, to renew the lease in respect of AC 120.00 decimal of land in Sabak Khata number 4 and 5, plot numbers 11 and 12, corresponding to Hal Khata numbers 451, 408 by 471, and 408 by 473 of Moza River Block, PS Kakatpur, in the district of Puri in their favor. Petitioners claim that the land in question was leased out way back in 1967 in favor of the petitioners to cultivate it as single quotes char land, unquote. They claim that the lease was granted in lease case number 69 of the 76-77 and 8 by 1 of 1977-78. Paragraph. On 19 January 2010, while directing notice to issue the petition, status quo was ordered, and that has continued since then. Paragraph. By an order dated April 2018, this court had called for the original record in temporary lease case number 210 of 1990 from the office of the Tahsildar Kakatpur. Mr. D.K. Mansi, the additional government advocate, states that the said record is still not available with him.
Your Lordship may kindly note the counter affidavit has been filed on 20th September 2010. That may kindly be taken.
All right.
Note.
In response
Page
to the petition, the counter affidavit was filed by the Tahsildar Astaranga. on
20th September 2010.
20th September 2010, inter alia containing that
Page 5.
documents relied upon by the petitioners were not genuine documents and appeared to be single quotes, forged, fabricated, and manipulated documents. Unquote. Full stop. In the meanwhile, a group of 16 villagers,
60 villagers, IN number
16 na 60.
60 villagers from the same village Astaranga have claimed that they are the rightful lessees of the lands in question, and they have filed IN number 1952 of 2019 in the present petition. Paragraph Ms. Deepali Mahapatra, learned counsel appearing for the petitioner, contends that the interveners had earlier approached this court with a writ petition which had been dismissed. Writ petition civil number?
Their claim has been rejected, my lord.
No, writ petition civil number?
That is, my lord, WPC number. That is WPC number 809. No. That is
809 is this.
This is. That is WPC number 21831 of 2016.
21831 of 2016, which according to was rejected.
Yes, their claim has
by
been
the
rejected.
learned single judge. Full stop. However, learned counsel for the interveners contends that they were in fact permitted to be heard before the Tahsildar. Full stop. Neither of them has a copy of the said order. Paragraph. Considering the above factors, the court directs as under: 1. The sub-collector
Puri
will examine the entire matter, and after hearing both the petitioners as well as the 60 interveners in IA number 1952 of 2018,
and verifying the lease case records.
And verifying the lease case records,
Concerned lease
including
case.
the record of lease case number.
Lease case number.
210 of
210, temporary lease case number 210 of 1990.
My lord.
Pass fresh orders. Full stop. For this purpose, the petitioners as well as the interveners will appear before the sub-collector Puri on 19 September 2022. The sub-collector will then, after hearing them and examining the records, pass a fresh order. As
4 months time maybe.
within a period of 4 months thereafter. Full stop. Till such time, the
Yes.
status quo order passed with this court on 19 January 2010 shall continue.
My
The court clarifies it has not expressed any view in the matter.
If required, my lord, inquiry at the spot may be necessary.
That's okay. That you can ask
will
him.
take a call.
Yes.
Sub-collector.
Yes.
Weekly list item number 11.
Make acknowledge, my lord, item 6 not.
You have to wait, sir.
Wait. Item number 11.
None appears dismissal not possible.
Weekly list item 12.
I may please your lordship. My lord, I am in VC, my lord. I am in VC, my lord. My lord, I may please your lordship.
Yes.
My lord,
Not
the
visible,
petition,
sir.
my lord, the petitioner before your lordship was a candidate peer, my lord. He was given appointment in the year 1988, my lord.
That system has been abolished now, sir.
My lord,
The system of candidate peon is now abolished.
my lord, he came to regular establishment in the 1993, my lord. Now he is a process surveyor, my lord. He is serving. Now till now he is in service, my lord, in justice of Jawasungur, my lord. The grievance of the petitioner, my lord, where he came to the regular
Sir,
establishment. in the-
you'll have to switch on your camera. You're not visible.
My lord,
We'll pass it over, sir. You get your systems correct. Pass over.
my lord, next week, my lord, your lordship.
No, sir. Sorry.
My lord,
Pass over.
now it is okay, my lord. Now it is okay, my lord. Now it is, am I audible, my lord?
No. You're not visible. Of course, you're audible. That's how you're talking.
My lord, now it is okay, my lord. My lord.
You're still not visible, sir.
My lord, only simple grievance, my lord. But
Pass
there is
over,
no.
pass over. Just call out the next matter. You are muted.
Weekly list item number 13.
Item 13, Lordship.
Item number 13.
Now it's visible. Anyway, let him. Yes.
13. No.
Yes, Mr. Where is he there? No, he's still not there. All right. Yes, please.
Lordship, item number 13, Lordship, may I pray Lordship may kindly dispose of the matter, giving liberty to the petitioner to approach the bank authority if cause of action survive. The petitioner.
All right. Counsel, the petitioner states that the petitioner seeks leave to withdraw the present petition with liberty to approach the bank authorities if any cause of action survives. Disposed of is withdrawn, liberty is paid.
Okay.
Weekly list item number 14.
My lord, on behalf of Mr. Deacon, I am appearing through VC, my lord, no instruction.
No instructions dismissed.
Weekly list item number 15.
15 may not made, please, my lordship. Your lordship remembers it, your lordship has earlier passed 2 orders, my lord. This is regarding the roadside vendors, my lord. This issue is going on from 1995, my lord.
Okay.
In 2013, there was a survey to find out the plots and availability of plots, my lord. Then, my lord, they didn't take any steps, and thereafter we have approached your lordship, my lord. On 3/3/2021, my lord, this matter was listed before your lordship, my lord. Last listed, my lord. Lord, your lordship may kindly see the order paragraph 4, my lord.
Last time, Mr. Mudali,
filed the affidavit. He has filed an affidavit. My lord, government has filed an affidavit. Your lordship, it is in record. Your lordship may kindly see. It is our rejoinder, counter by the government. Yes, I have got it. Your lordship sees.
That is affidavit dated 6/8/2021.
Yes.
There, my lord, your lordship will kindly see it.
If my lord, permits, I can place the affidavit.
Yes. Ticket one through. Lord, your lordship will kindly see what they have told me, Lord. First, your lordship may read paragraph 13, page 5, internal page 5 of the counter affidavit, my lord.
Yes.
Has your lordship got it?
Yes.
That it is further submitted that suitable land in the vicinity is not available for allotment in favor of Bhubaneswar Municipal Corporation. Even though Bhubaneswar Municipal Corporation has requested for allotment of land measuring 1 acre, by letter number such and such, no specific land schedule has been indicated for consideration. Then that in view of the above submission and subsequent development of the Janapatha Smart City project by Bhubaneswar Smart City Limited, Bhubaneswar Municipal Corporation may identify suitable government land in the vicinity in consultation with the petitioner, Bhubaneswar Development Authority, Bhubaneswar Smart City Limited, and submit specific proposal under OGLS Form 1, Miller. Lord, it is a question of settling the land in their favor. They took 5,000 rupees from each of us for allotment of Kesak. Then they told that it will be constructed at your own cost. We are agreeable. Many of the persons were given. Then we are not given. And we have been fighting out the litigation, my lord. In 2015, my lord, the BMC wrote to them, because the survey was in relation to plot number 295. So question of permanent allotment of that plot number 295 was. Now they say that Bhubaneswar municipality will involve us, involve BDA, involve Smart City Limited, a private corporation, my lord. And they again say that it is meant for a public plaza. Then they say that it is for the road, my lord. I don't know. understand the intention, my lord.
No. They're looking for alternative land for rehabilitation, right? That was the direction issued by this court in the writ petition.
Yes, my lord, in the vicinity. Now, my lord, in this process, this will go on, my lord.
No, but if they can't find land, they're saying you get together, you tell us which land and you tell us and then we'll do it.
That land, my lord, your lordship may see that land where we are there. They have conducted a survey and admitted that we are running those serves. My lord, that is in their annexure, page 9, my lord.
Page 9.
Of the counterment.
Page 9. Page 9. Page 9.
Has your lordship got it? Of that counterment.
Yes.
They say that we are there. And the BMC also admits it. Now they have thrown the ball to the BMC's court telling that no, you find out no land is available, you find out a suitable plot along with discussing with the Smart City Project Limited. On the one hand say that it is meant for public plaza, another hand they say that it is marked for in the master plan road is already constructed, flyover is already constructed. Lord, we are poor persons who have been agitating your grievances, and it was because of your lordship's intervention. Many persons in other areas have been, and in this area has also been.
But what was the order in the writ petition, please?
Lord?
What was the earlier order?
Earlier
in the
order.
writ petition.
Earlier order was to consider them to refer the
Where is the order?
My lord, that is. I won't say it in first is, my lord.
Page 39.
Page 39, my lord. The subsequent second writ application. At that time, eviction notice was given. That is, this was required for flyover. We came before your lordship.
2009.
This was in 2009.
There was a survey in 13.
There was a survey in 2013 thereafter.
No. So it's very clear. This court has said, in view of the above, the writ petition is disposed of with a request to the opposite parties to consider the petitioner's claim for rehabilitation in alternative places.
Yes.
So it can't be in the same place, sir.
In the vicinity, I am.
No, if they are not able to find land, they are turning to you and saying, you find the land and tell us, we'll do it.
This is, process is continuing. This is continuing from 1995. That is my anxiety.
To appreciate the point, my learned friend, in fact, submitting the fact. My lord, the flyover has been constructed from Kalpana Square up to that is the Rajpath, towards the Rajman Square. So that itself is an expansion. So on the side of the flyover, the area marked is for parking of the vehicles in that area. So that parking area, these 2 decimals of land is being occupied by these present vendors as per the survey conducted in 2021. Okay. That's the situation. How that land can be allotted? It's a parking space.
My lord, your lordship, may I just for a minute intervene, my lord? Can your lordship look at page 72, that is annexure 14 of the rejoinder, my lord? That is a letter from the BMC.
After 9.
In 2011, my lord.
Yes.
Has your lordship got it?
Yes.
To the Secretary Bapujanawar Khurda Vyavasai Association Bhubaneswar, subject relocation. You are hereby permitted to relocate 25 number of Kishak over plot number 295 as per sketch map accepted by Executive Engineer 2 Roads and Building Division. The cost of relocation with temporary roof shall be borne by the individual allottees. However, BMC will continue to collect the rent as applicable from time to time, and this allotment is subject to cancellation as and when public purpose.
Public purpose, all right. So that is there.
May I place my affidavit?
Then 2013. Well, without joining an issue, well, can they solve it?
The only problem is where do we find the land? That's the whole problem. That's why in his affidavit he says you get together, you find the land, we can do it.
That is municipality, they have directed to find out the land.
Yes.
Municipality is not the owner of the land, my lord. The landowner is the state government. State government is earmarked which land we have to construct.
They are telling that you find out in the vicinity along with consulting others and then apply, they will allot.
Vicinity, no land is available according to the government's communication.
See page 77 of the region.
Then your lordship sees that order your lordship has taken note of on 3.3, my lord.
Yes.
Page 77.
Yes.
That's the report. In this case,
There's a joint field inquiry, sir.
Yes, my lord. This is in between the roads and building and yeah.
No. What does it say?
They refer to that plot number 295, the detailed sketch map indicating the existing kiosks and vacant space for construction in use attached herewith. The existing kiosks are constructed leaving a clear space of minimum 10 feet from the existing overbridge. The new kiosks may be constructed leaving a clear space of minimum 10 feet for road and drain for the overbridge. So they are again and again changing their stand.
May somebody kindly see the prayer at page 10, and their specific prayer is they should be rehabilitated over plot number 295.
Yes.
That is the special. Now you Lordship kind on to my affidavit, letter 6/8/2021.
Yes.
I am replacing from paragraph 10, internal page 4.
See, that
the additional commissioner BMC in letter number 6132 dated 9/3/2015 and 1466 dated 7/5/2015 has requested for sanction of land and allot in favor of BMC in respect of area measuring acre 1.000 decimals of government land for rehabilitation of the petitioner in compliance with the orders passed by the Honorable High Court in WPC number 70. That suitable government land measuring area acre is not available in Unit 1 Bapujinagar area for allotment of alternative land. The prayer of the petitioner is to regularize the allotment process in respect of plot number 295 or to allot alternative land in the vicinity. Plot number 295 is not suitable at this stage due to the fact that the area has been kept for development of public plaza under the Bhubaneswar Janpad Smart City project. Further, Bhubaneswar Development Authority did not accord possession in favor of Bhubaneswar Municipal Corporation in respect of plot number 295 for construction of kiosk, even the permissive possession was granted in favor of BMC by GA Department letter number so. On verification of the comprehensive development plan of BDA, it is seen that plot number 295 and the adjoining plot number 294 and 296 are coming under red zone. Road zone. It is further submitted
under road zone, not road zone.
Under road zone.
Yes. How can there be a public plaza in a road zone? And public plaza, they will give it, lease it out to private persons.
No, it is.
No, but even they will not get it if it is in the road zone, sir.
The one thing they say that is what I read out, your lordship. Well, they are contradictory. That it is earmarked for public plaza and it is also coming under the road zone.
No, where is it say it's earmarked for public plaza?
Yes, my lord.
No, 295 is earmarked for public plaza. 294 and 296 are coming under road.
Paragraph 11, the plot number 295.
295 is public plaza.
Yes. 294 and 96 are coming under road zone.
Your para 12 is a bit misleading. It seems to indicate that.
No, that is not, because in para 11 it is clearly that 295 is for.
That's what I'm saying. 12 is not correctly worded.
Yes.
I have filed a rejoinder disputing it, my lord. But your lordship, Levinite may not get into, I don't think so. To which
It's earmarked, sir. There must be a municipal plan, a layout plan or something.
Yes. The layout plan, but that is Smart City Limited, my lord.
No.
My lord, I will tell your lordship, previously there was a Asoka market near the station, my lord. 4 years back, they evicted the persons whom they gave the lease in the Osaka market, telling that they would be rehabilitated elsewhere, and they gave us a time, and we came to the court. Court gave us a time. We gave an undertaking that they will, after rebuilding, they will reallot the same with enhanced rate, whatever rate is the market. Till now, not a single brick has been laid in that street. Demolished. They have handed it over to Smart City Limited, something.
No, the only other way is then you continue where you are. Don't ask for settlement. Because it's a see, if you want it to be settled, you'll have to move to alternate space.
40 years somewhere.
No, that's the price one pays. That's the whole problem in these kind of situations.
That 40 years, at least
you want them to formalize. See, you want them to formalize this arrangement by saying, allot us the land here itself. Wherever we are, because your prayer is, we are now in 295, settle in 295 itself. That's your prayer.
Even in the vicinity to do.
Tell us. That's what they are telling us. See, as a court, can we create land? We cannot.
No.
Either the state should tell us where that vacant land vicinity is.
Either state or the BMC should tell.
No. So, or you tell. You say, sir, there is this vacant vicinity, vacant land. They're not pointing out this to you. We are sure that there is vacant land.
The vacant land we have shown them, but they are telling that it is reserved for something. So they are the competent persons who can say. And they have directed the BMC to find out the vacant land. Now BMC is telling that state government will tell, we don't know. How can this go on?
We don't have any vacant land.
No,
Mr. Mahapatra.
My lord.
You don't have any vacant land?
No vacant land, my lord, in the vicinity.
We are here 40 years.
So how do we break this impasse, sir?
My lord, that's a lots of the kind dance to that page 9 of the state's reply, page 10, my lord.
Yes.
The person those are doing business are iron steel market. How that can run, my lord, in the parking area, the side of the road? These are the type of stalls there.
Anyway, sir, you have not taken any action. They have come to the court saying rehabilitate us there. So
the predicament of the corporation, my lord, we are not the owner of the land. Whatever land is given to the corporation by the government, we go by the scheme. So corporation don't own any an exclusive land for any market area. Wherever market area allotted by the state government, we go for construction.
Initially, they agreed. Both government and
we never agreed. We never.
You have allotted us the Kishans. You have taken money from us.
No.
And
that money been refused, and you didn't turn up to this.
Refused. Lord, it is not a question of brushing the egos of the BMC or it is a pro bono litigation, where there before right from 1995.
No, if where does as a court, where are we supposed to find land? You tell us.
So they must say that there large number of, your lordship has seen that Bhubaneswar, large number of Kishaks, large number in vending zone. They cannot find out anything for us, and they say that
you tell us, sir. If they are not telling us, you contradict them. He says there is no land in the vicinity. You contradict him by showing where is that land in the vicinity.
Today we must have access to that municipality record and government record.
No. So if you go plot by plot, they'll tell you who it has been allotted to. When he's saying there's no land in the vicinity, we have to take that on
Already 295% in plot number 295, that 25% are already there.
Correct.
Only left out is we left 25%.
No spaces they have, they are giving the report.
And for 25% Kisaks, well, they would definitely not need 1 acre. A small spaces.
No, you are not those. What are you carrying on? What are you carrying on the shops?
18 persons, my lord.
Small trips.
Your lordship will kindly see.
No, this annexure 18
to
the rejoinder.
Yes,
there are 36 persons.
Cycle repairing shop, tiffin shop.
No. So you are all part of this 36, correct?
25.
No. There is annexure 18.
Annexure 18.
Gender.
Regender.
Last. That's because the list of their list. Survey.
Your lordship will say, Bittle shop, fast food, tiffin, tea stall, Bittle shop, tiffin.
No, cycle repairing, hardware. There are so many hardware shops, sir. How can you have hardware shops? I don't know. Bed and mat shop, everything. These are regular shops.
Tricycle shop, pool shop, steel. There are about 5 to 6 steel store.
That's hardware. They say hardware, so it must be the same thing.
Tools, food. एगुड़ा तो सेमन अलर्ट कर दी चंद ना. These hardware shops have been authorized, my lord.
No. Are you part of these 36 or you're beside this? You're part of the 36.
Any number possible? That
Mr. Mohanty, this situation is very simple. You are as it is on 2295, correct?
Yes.
So you continue in 295 subject to whatever they may do. I don't know. If you think your situation is precarious, you want some permanent structures, a permanent place where you will not be disturbed, then it has to be at a distance wherever they find land.
And let that be a reasonable distance. We don't mind, Lord. But every time...
Which is the nearest place where you can find land? You tell us, Mr. Mahapatra.
My lord, within 3 kilometers radius, there is no possibility.
Wherever, sir, you tell us where the land is, then we can...
I'll come back to my lord. I have to find out.
Your lordship also directs the GA department. They must be knowing where the land is.
We have requested the BMC in consultation with the petitioner. They will find out the place.
Petitioner go to
My lord, this is the heart of Bhubaneswar. There can be available land within 5 kilometers radius.
Mr. Mahapatra, you have got a lighter job then. So much of land, why don't you give?
Mr. Mohanty is having so
heart of the Bhubaneswar, you are there. Have some compassion.
This is the third round of litigation.
What is the real objection to 295?
This is the third round of litigation concerning the claim of the petitioners who are 25 number.
25.
And running kiosks upon vacant government land in plot numbers 295 and 304 at Bapuji Nagar near Rajmahal Square, Bhubaneswar since 1980s by paying license fees collected by the Bhubaneswar Municipal Corporation (VMC). The first writ petition was OJC number 6483 of 1995. which was disposed of on 9th August 1996, directing the opposite parties to consider the case for rehabilitation at single quotes alternative places, unquote, full stop. This was reiterated by an order passed on 11 September 2009 in the second writ petition, civil number 4643 of 2008. Full stop. In the present writ petition, a detailed order was passed by this court on 3rd March 2021, pursuant to which an affidavit has been filed by the opposite party number 1 state, in which it is stated in para 12 as under, in which it is stated in para 11
Para 10, we have stated 1 acre vacant land is not available.
Okay, in paras 10, 11, and 12 as under. That's actually 10, 11, 12, 13 as under paragraph. It is accordingly submitted by opposite party number 1 that the BMC should identify suitable government land in the vicinity in consultation with the petitioners, Bhubaneswar Development Authority and Bhubaneswar Smart City Limited, open quotation, and submit specific proposal before the General Administration Department for consideration in the prescribed form number 1 as envisaged in Orissa Government Land Settlement, bracket Second Amendment, bracket Rules 2020, unquote. Counsel, Mr. Manas Mahapatra, Senior Counsel appearing for BMC, submits on instructions that there is no plot available in the vicinity of the aforementioned plots 295 and 304 of Bapuji Nagar. Full stop. Mr. Ashok Mohanty, Senior Counsel appearing for the petitioners, submits that it is the BMC which should locate the land, even if it is not in the immediate vicinity, at least at a reasonable distance, in order that the petitioners may be rehabilitated. Mr. Mahapatra states that he needs time for instructions on this aspect. Full stop. The BMC should file an affidavit indicating, or do you want to have a meeting with them and point out to them where the lands are available? That would be much easier.
My lord, either they suggest an area where it is available.
Where from I would suggest.
How can they suggest, sir?
Operation.
You have all the records. BMC has all the records. They will simply, if they see a vacant plot, they will simply say, okay, put us here. That doesn't mean you will put them there, right?
Yes, we will be conducting a survey along.
Then this will become a rigmarole. It's better you tell them, listen, there are vacant plots A, B, C, and D in these locations.
That will be better.
That's far better. You see, the Commissioner BMC is requested to place before the representative of the petitioners at a meeting to be convened in the next 1 month with at least 1 week's advance notice to the petitioners, certain alternative proposals of alternative plots at a reasonable distance from where they are presently located, and offer the petitioners the choice of one of them. Full stop. An affidavit in this regard we filed on the next date. List on
End of September.
End of September.
29 September.
Yes, ma'am.
29 September.
Interim order to
continue. Right.
Well, let us hope that some puja.
That's right.
Puja gift is available.
If Mr. Mahapatra so determines, he can.
My lord, I know. I know the entire picture while I am in the city for
Mr. Mahapatra possesses vast piece of land along with his house in a commercial locality. Glad to God.
5 years in Bhubaneswar. I know the nook and corner. The place my friend is asking for, totally not possible within 5 to 6 kilometers.
Please don't give. Find out something for this.
My lord, may I permit it, my lord? I am also
don't want
resident of
to
Bhubaneswar.
I don't want to hinder
Mr. Mahapatra, we are resident of Bhubaneswar, permanent resident of Bhubaneswar. This is our settlement 290 was done by the municipality from 95-90 already. Our case was not done, we came to my lord. My lord to verify. They verified, gave us the allotment. Now, for what reason they are averse to settlement 295, I really don't know.
He got around.
No other purpose to use.
All right.
Mr. Mahapatra agrees, it can be done.
All right.
Weekly list item number 16.
May it please, Your Lordships. Lordship, this is, I've come up in challenge against the order of the passed by the single judge in appeal. It has been rejected on the ground that for non-availability of records and non-joinder of necessary parties.
Yes.
Lordship, I would like to draw your attention to Annexure 5 of the writ petition. I may be permitted to place
Yes.
the fourth line, Your Lordship. It starts.
Yeah.
It is obvious from the statement that there was selection of ashas in the village in proper manner in presence of A&M, AWW, and SHG and the candidates. When in selection process, unanimous is not being done, there was decision for lottery. When in lottery, the name of Saraswati Giri, that is the present petitioner, was lifted for Asha, other aspirants for Asha and 2 SSH group members left away from the selection site without signing the register and selection format. As per statement of A&M, or the AWW took the register and the selection format at the time for signing in the subsequent, she did not return it back and denied that she has taken the register. Lordship, this is the document which is alleged that it has, because due to non-availability of this present document, her appointment letter has not been issued and it has been rejected, Your Lordship.
No, but what do you say to this? Come to page 10, bottom.
Yes.
Furthermore, just read that paragraph.
Page 10 of the
Writ appeal.
I'm sorry. The last paragraph, you know?
Yes, please.
Furthermore, it is seen that the case of the petitioner is that there were 2 candidates whose fate was decided by draw of lots. She and one Gauriman Jenna was considered for the said post. The petitioner was has not made Gauriman Jenna a party to the writ application. She is the unsuccessful candidate, Your Lordship.
Sorry?
Gauriman Jenna is the unsuccessful candidate. Your
Yes, that's right. But how come you have not made her a party? And the second problem is you've taken away the records.
I have not taken away the records, Your Lordship. It is the Anganwadi worker. She had taken it for signature and she did not return it, saying that it was not with her. That has also been held in the inquiry
Same page,
report.
previous para, you can see. It starts.
Yes.
It is borne out from the records that as per the statement of witnesses recorded during the inquiry, there was no unanimity in the selection of Asha. Therefore, the selection was done by drop lots as per the guidelines. But the same was not reduced into writing and was not signed by some members present in the committee. Though it is alleged that the said document was kept by the Anganwadi worker, the same has not been produced before the authorities. Whenever a document is alleged to be in
How are we supposed to? How are we supposed to then go by your statement that you were successful in the lottery? If there's no record for it, how do we know that?
It is not disputed that in the counter also they have not disputed that I was not selected, Your Lordship. I am the selected candidate in the lot.
The process has not been filed. It has not been signed by all the members.
Due process has been followed.
No,
but because of
they
that
don't agree that everybody signed it.
Yeah, but the same was not reduced into writing and was not signed by some members present in the committee.
Yes.
According to Annex 5, Your Lordship, they had signed it. That particular those two members,
Yeah.
since they left, they said that we'll sign it later, and they took it and they did not return it.
This case, in this type of
So
cases,
all that's been asked is the authorities should be asked to call for a meeting again. So why not? What's wrong with that? That's a correct
this
order
type
to
of
pass.
cases where records are not available, man, clarification has been issued. Your Lordship, kindly see next are C by
Now
3.
that process must be over. There's no stay, no?
There is
No
a stay
stay.
order, is there?
Then you yourself have asked for a stay and
No, we have to go for
closing
fresh
the whole
election.
thing. Yes.
Well, in view of clarification at page 26 of our counter annexure C by 3, well, we have to go for fresh election.
Correct, correct.
Since the records are not available.
Correct.
But here, Your Lordship, the petitioner is prejudiced because
What's wrong? So you might, if you are qualified, you'll get selected. The petitioners aggrieved by the order dated 3rd March 2012 passed by the single judge disposing of writ petition civil 22192 filed by her of 2010 filed by her for a direction to the opposite parties to engage her as ASHA in respect of Rautunda Anganwadi Center bracket 2 near Pratapur PHC. Full stop. Paragraph. The case of the petitioner, the case of the appellant is that a meeting was held on 25th February 2009 for selection, which is presided over by the what is LHV?
it is is this
Lady health visitor.
Sorry?
Lady health visitor.
By a lady health visitor.
Primary health.
Of the primary health center of Pratapur. Full stop. After deliberation, the name of one Gauri Mani Jaina and the appellant were proposed for selection. So, since there was no unanimity among the members of the selection committee, they decided to go in for draw of lots. Full stop. Apparently, the appellant's name was selected. Full stop. The appellant claimed that the resolution was drawn up and signed by single quotes most of the members present at the meeting, and yet she was not given the appointment order. Full stop. The learned single judge noted that the selection done by draw of lots was not reduced into writing and was not signed by some members present. So, in fact, no document could be produced before the authorities because apparently an Anganwadi worker took away the register and selection format at the time of signing and did not return it. Paragraph. Learned counsel of the appellant.
May I pray, Your Lordship? Annexure 1 is the Xerox copy of the resolution. We just don't have the original of it.
All right. Is unable to dispute the fact that the original record is not available. Full stop. The second factor on which the second reason why the learned single judge did not grant the relief as prayed for by the appellant was that Gauri Mani Jaina, the other candidate, had not been made a party to the writ petition. In the circumstances, the learned single judge is directed the opposite parties to hold a meeting again to have a fresh selection process as per the rules. Paragraph. Having heard learned counsel for the appellant as well as learned counsel for the state, the court is unable to find any error having been committed within a single judge that calls for interference. Full stop. Indeed, if the original record is not available, a mandamus could not have been issued by the court for the opposite parties to issue an appointment letter to the appellant. Full stop. Consequently, there is no merit in this appeal and it's dismissed as such. The interim order is vacated.
She may be considered in the next.
No, if you participate, you can always participate in the fresh selection process. Yes.
Weekly list item 17.
17, my lord, no interim order is there, my lord. Pursuant to direction, the writ application is pending, my lord. Against the interim order, we have filed the writ appeal, my lord. Pursuant to direction by the single judge, my lord, petition institution already appeared in the 2012 Upashastri examination. Whether in the meantime their result has published or not, because their single judge has categorically restricted that without leave of the court, no result shall be published. And lordship may be.
He said, due to effects of time, the present writ appeal has become infructuous and is disposed of as such. Right.
Weekly list item 18.
My lord, this petition has become infructuous.
All right. Writ appeal is stated to become infructuous, disposed of as such.
Weekly list item 19.
Item 19, my lord, I am appearing through VC, my lord. I am submitting on behalf of Mr. B.K. Naik, my lord.
Yes.
Here, my lord, I have challenged the order of the Honorable Single Judge, my lord, at page 13, my lord.
Yes.
Wherein the petitioners, in those writ petition has been provided appointment, whereas pursuant to the advertisement dated of the year 2011, I was selected and I was called upon for verification of the documents, and I was not given appointment because of the order of the impugned order under Annex 13, under page 13, my lord. The Honorable Single Judge has directed one of the petitioner to be appointed in my Gram Panchayat, my lord. That is Jamsara Gram Panchayat. The impugned order is at page 13, my lord.
Yes. What is GRS?
Gram Rozgar
Sevak. I was selected pursuant to the advertisement under Annexure 1, my lord, and under Annexure 2, I was called upon for verification of documents. But thereafter, I was not issued with the appointment order because of the impugned order under page 13, my lord.
What is your grievance?
My grievance is that respondent number 5 has been given appointment in my place, my lord, in my Gram Panchayat.
All right.
Selected.
You are not heard by the single judge?
Yes, my lord. And there in that case also,
No, you were not made a party or what?
Yes, my lord. Yeah, I was not made a party, and the fact was also not brought to the Honorable Single Judge that a subsequent advertisement was issued, and I was selected in those advertisements. And that ground I have also taken. That is at page 5 of my writ appeal, my lord.
Right now, is there a stay here?
Yes, my lord. There is a stay.
So you have been working?
I have not been issued with the appointment order, my lord. That is the issue.
Who's appearing for the contesting opposite parties?
My lord, I am for the respondent number 5, my lord.
Yes.
My lord, this is a common judgment in two writ applications. Two JRS, they are fighting for the place of posting, my lord. The lordship will find two selected JRS, the recruitment of the year 2007, my lord. The petition number 2007, he wanted to took my place at Khuturam block, my lord. In between the regarding place of posting on basis of residence, the court on consent directed that he may be directed in my place, I may be posted in Jamsura Gram Panchayat, my lord. And so invoke the consent of the parties and the state government. My place of posting has been changed from Khutuga block to Damsura block. This writ applicant is a simply applicant in 2011 advertisement. My
No, but he was not made a party to your writ petition.
he was not a party, my lord, because he was
And my specific ground is that subsequent advertisement was also not brought to the notice of the Honorable Single Judge, either by the parties, by the petitioner or by the Council of the States, my lord. That's like ground number 10 at page 5, my lord.
Right.
My lord,
because of the insufficient.
My lord, he cannot.
My lord, the Honorable Single
Judge, he cannot execute
order
2011 advertisement
to be engaged
in
as
a writ appeal, my lord. He should have gone to the single judge instead of coming in appeal.
Why not, sir? You should have made him a party. Why did you not make him a party?
Because it is regarding choice of posting, my lord. I was in Khutura block. The court by asking the state government and with the consent of the parties has given that place of posting.
Consent of which party? The affected party is not there before the court, so consent of which party?
He was not appointed. That is a simple advertisement.
No, but he has been selected, sir. He's only not been issued a letter. He has been selected.
He has selected no appointment order.
Page 9, my lord.
That is the government has given that he may be posted in that place. That is the consent of the government. Let us see the order. By consent of the party.
There is no estoppel against as far as the present appellant is concerned. If he had an appointment, he was short of getting an appointment letter. That's it. Otherwise, he has been selected.
My lord?
There was a consent between the state and the applicant, but that remains ultimately his interest is prejudice. That is the
absolutely.
Consent of parties, my lord. Even at present, I am not working that Gram Panchayat, my lord. I have been transferred from that place.
Since 2013, the engagement of respondent number 5 has been.
That criteria of place of posting in the residence is no more available. He can be adjusted at any place. I am also not in that Damsel campus done by it. Now I have been transferred. At that time, I have been, by order of the court, I have posted there. Now I have been shifted to another Gram Panchayat. I am not now in that.
If you have now been shifted to another Gram Panchayat, then can he be appointed wherever he's been selected for?
My lord, that is on consent of the parties and the state government itself.
Sir, don't say both things. If you're now working in some other place.
Now I am not in that at present, my lord.
So why should you then go back? If you're happy where you are, then leave it be.
My lord, I have been, in my place, another person has come, my lord. The Sahu has come. Munna Sahu, my lord.
Where is he? Who's representing him?
Is respondent number 4, my lord.
No, who's representing him?
I am for the opposite party number 4, my lord. The appointment of OP number 4 is not under challenge, my lord.
Yes.
And on merit list, my lord.
No, you have come in place of opposite party number 5. That's what this council says.
No, my lord. For that place, he had not applied for that post. He applied for the post Ankurpali Gram Panchayat. That is the reason my candidature was confirmed. He did not apply for the post belongs to this, my lord, Bakunthapalli. Kuntagaon, sorry. The appellant number 5 did not apply for the Gram Rozgar Sevak.
And the whole confusion is that at that particular period of time, the Honorable Single Judge was not properly instructed about the updated advertisement, my lord. Because of that, all this confusion has been created. Respondent number 4 initially challenged the appointment of respondent number 5 for his appointment in the Kuntagaon.
No question of challenging appointment. It is dispute regarding place of posting, my lord.
Yes, they are
Appointment was never challenged.
in WPC 17023 of 2007, my lord. The counter affidavit I have also annexed in my appeal, my lord. That is at page 20, my lord.
My lord, that is only regarding, I have been in Kuntagaon Gram Panchayat, my lord. My place has been taken by the respondent number 4.
He's disputing that. He's disputing that.
OP number 5 did not apply for Kuntagaon Gram Panchayat. That is the reason.
No, I have applied, my lord. That is there is record. That is there in record.
The counter filed by the
merit court has directed.
Counter filed by OP number 1 and 2 in the writ application. In the writ application 17023 of 2007 clearly shows that.
No, 1 minute. Neither of you is in Jamsara Gram Panchayat right now.
No,
my.
So what is the problem then? Let the appellant go there. That's where he wants to go.
We have no objection. Now we have no.
That's the end of the matter, sir. Why are we going around
everybody will be satisfied.
now?
Everybody will be satisfied.
That's all. You say the petitioner, the appellant's grievance is that he was selected by the selection committee for appointment as Gram Rozgar Sevak (GRS) in respect to the Jamsara Gram Panchayat (GP). Stop. However, before an appointment order could be issued to him, the impugned judgment of the single judge came to be passed on 3rd July 2012 in writ petitions numbers 2081 of 2009 and 17023 of 2007, whereby respondent number 5, Hemraj Sahu, was asked to be appointed as GRS in the Jamsura Gram Panchayat GP paragraph. This court, while entertaining the present writ appeal by issuing notice on 3rd January 2013, stayed the operation of the impugned order. So the main ground on which the impugned order has been challenged by the present appellant is that he ought to have been made necessary and proper party to the writ petitions and should have been heard before the impugned order was passed. Paragraph. Counsel appearing for opposite party number 5, Hemraj Sahu, informs the court that during the pendency of the writ appeal, Mr. Sahu has again been transferred and is at present working in the what GP, sir?
Sahu.
Where is he now working? Hemraj Sahu.
Shifted to another GP. I have not exactly. I cannot say.
Okay, to some other GP from Jamsura GP. Counsel for applying for Munna Sahu, opposite party number 4, also says that he is not working in Jamsura GP but in
Kuntagaon Gram Panchayat.
Kuntagaon GP. So, consequently, there is no hindrance to the appellant being appointed as GRS in the Jamsura GP, for which he was originally selected. Full stop. I hope there's nobody else in Jamsura GP.
That is why just now.
Instructions I don't have, my lord.
That is her. If somebody in the meanwhile joined that Jamsura GP, then it will be again, the appellant will be.
When will you find out? You will only have to find out and tell us.
That only I can find out.
Can you pass it over and then you can find out?
But we have no up to communication with the petitioner, my lord. Only the state council can help.
No, that's what I'm just asking whether he can get it on phone.
After 2 p.m.
So we'll just retain the order. Call it 2 p.m. All right.
Oh, please, my lord.
Weekly list item number 20.
In item 20, no instructions, man.
No instructions, dismissed.
Item number 21.
No, none appears, dismissed or not.
Item number 22.
None appears, dismissed or not.
Weekly list item number 23.
None appears.
Weekly list item number 24.
Next week on behalf of Mr. S.K. Jolai.
What's the matter about, sir? What is the matter about?
I don't know. He's not well.
We have to know what the matter is about. We are not sitting here to grant adjournments only, sir. Please don't presume that we are sitting here only for adjournments. He's walked away.
Hey,
My lord.
What have you thought? This is a court or what?
I don't know.
You don't know? Come on, tell us what the matter is about.
I don't know.
What is your name, sir?
S.K. Biswal.
One Mr. S.K. Biswal appears in the court without any paper book. He just walked into the court, asked for an adjournment, and even before the court could react, simply started walking out. Full stop. When he's asked to explain to the court what the case is about, he was unable to do so. Full stop. The appeal is dismissed for non-prosecution.
Weekly list item 25.
Sorry, ma'am.
None appears, dismissed for non-prosecution.
Weekly list item number 26.
May I please, your lordship? My lord, I am for the opposite party. I have been awarded.
None appears for the petitioner, dismissed for non-prosecution.
Weekly list item number 27.
On behalf of Mr. Patnaik, that petitioner applied for rehabilitation assistance scheme. His father died on 14/5/2000, and he has applied on 4/9/2000. And
so the old policy will apply according to you.
Yes. This is the latest judgment that went from this honorable court.
Correct. Justice M.R. Shah.
That Malayananda Sethi.
Correct. What is your current position on that?
Well,
So many petitions, you've been taking time for this.
Yes, let's on the last of if my lords remembers, that particular question
has been referred to a larger bench.
Has been referred to a larger bench, and it is
that has been taken care of this judgment.
Malayananda was specific to that particular.
No. That they have taken care of the N. Santosh Kumar, the 3-judge judgment.
It doesn't.
And this is also from this honorable court.
No, maybe. No, but they've noted that there's a conflict. Para 5. Just see that.
Para 5, they note that there's a conflict and.
Yes, that they have considered. Considering all these aspects.
No, but they're saying that they're doing it in special circumstances.
Yes.
Peculiar facts, we are doing it.
Yes, but they have considered that all these aspects. And even if there is 3-judge judgment of this of the Honorable Apex Court, and so also the other cases, they have considered because of the delay on their part. Because of the delay on their part. It is very specifically clarified that they have to take a decision within 6 months. And that because of the delay and laches on the part of the authorities, the person should not be suffered. On that ground, they passed this order. And this is similarly applicable to my case also.
Here, the authority is OCCL, which is Orissa Construction Corporation Limited. There is some, I am not appearing for OCCL, but to assist the court, may turn to page 32.
And here, my case is also different.
OCCL scheme does not
envision employment given on compassionate ground. On the other hand, they only give a one-time settlement, one-time financial assistance of 1,50,000, my lords. My lords might turn to page 32 of
My case is also that in 2009 rules, even if assuming that I have also covered, they are said which are already settled, which have agreed upon. Here in this case, the construction company already referred the matter to the government for approval. So my case has already been settled as per their own, the amended the rules 2009. And this is also in their case, even if 2009 is considered, I am eligible.
Page 32, my lords.
You are not appearing for the corporation?
No, my lords.
Who is appearing for the corporation? So you should know who's appearing for the corporation. Orissa Construction Corporation Limited. They filed a counter also.
Yes, but copy also not served.
Oh, copy of the counter filed by opposite parties 2 and 3 be served on counsel for the petitioner within 1 week. Resorted that if any be filed for the next list on. You just give it back to, we have copies. 11th October. All right.
Weekly list item number 28.
None appears to dismiss non-participation.
Weekly list item number 29.
None appears to dismiss.
Weekly list item number 30.
None appears to dismiss.
Weekly list item number 31.
None appears to dismiss non-participation.
Item 32.
My lord, for non-supply of information in time, I've been penalized, imposed penalty of 25,000.
How much?
25,000.
What is there, sir? Nothing. 25,000 is nothing.
I'm a clerk, my lord.
No. 25,000 is nothing, sir.
9 months delay, my lord. My lord, it is. I'm a clerk, my lord. Junior clerk, my lord.
So what? Today clerks are earning quite handsomely, sir.
It is long back.
Yes. After your 7th pay commission, all your pay commissions, everybody is earning handsomely.
2,000.
This is not even 10% of 3 months' salary and all. If you put together, it won't be that. All right. The present petition has been filed, questioning an order dated 10th February 2012, passed with the State Information Commission, imposing a penalty of Rs 25,000 on the present petitioner for failure to furnish, for a delay of 99 months in furnishing information under the Right to Information Act, bracket RTI Act. Full stop. The petitioners stated to be working as a clerk at the relevant point, junior clerk, the office of the Tahsildar Bhubaneswar. Full stop. While 25,000 may have been a substantial sum at the relevant time, considering the pay increases, it's no longer an unreasonable sum. In any event, the petitioner has had the benefit of an interim order in the present petition since 7th May 2012. Also, having heard under counsel of the parties, the court is not inclined to 7th June 2012. Having heard under counsel of the parties, the court is not inclined to interfere. The petition is dismissed. The interim order is vacated.
I am appearing for opinion over on State Commission, my lord.
All right.
Weekly list item 33.
Item 33, I am for the petitioner, your lordship. In this case, opinion number 3 didn't file any counter to the petition, your lordship. They are constructing a drain over my private land. My allegation is that they're constructing a drain over my private land. For that reason, I come before the Son of God, and the Son of God granted status quo over the property. But they have not filed any counter till yet, your lordship. OP number 3, the NSC Patamundai.
Has been served. We'll just pass it over on. Mr. M. Das has entered appearance for OP number 3.
Last 2-3 applications, they have not appeared, Your Lordship. On 1/11/2012 also, he has not appeared. 22/6/2015, they have not appeared. Even though they have entered appearance for the Patamundi municipality.
All right, we say despite notice having been served on opposite party number 3, that is NAC Pattamundai, and counsel also having entered appearance on its behalf, till date, no counter affidavit has been filed in the present petition, despite 3 adjournments granted for that purpose. Stop today, none appears also for NAC Pattamundai. Paragraph, the main grievance of the present petitioner is that the opposite party number 3 are trying to demolish the house of the petitioners, standing over Khata number 1163, plot number 1983, AC 0.020, and plot number 2001, AC 0.010 in Moza, Beltal, PS Mattapunte. For road widening.
Yeah.
This court, while issuing notice in the present petition on 7 June 2012, state the directed status quo to be maintained. So that has continued for over 10 years. No attempt has been made by opposite party number 3 to even have it vacated. Full stop. With no counter affidavit having been filed and none appearing on behalf of opposite party number 2, the court makes absolute the interim order passed on 7 June 2012. Full stop. In the event in future, the NAC Pattamundai seeks to requires the land in question for any road widening, it should do so only after following the due process of law and after sufficient advance notice to the petitioners. The petition is disposed of in the above terms.
Oh, blessed your lordship. Weekly list item 34.
34, my lord, the petition has expired. My lord, the legal heirs are not in my contract.
All right. Concept the petitioner states the
I am
petition is
appealing
expired
for opinion number 4.
and his family is not in contact. The petition is accordingly dismissed as having abated.
No, I am appearing for opinion number 4. My appearance will be recorded.
All right.
Weekly list item 35.
Lordship, in a similar matter, on 29/6/2022, the matter has been disposed of within the parties, your lordship settled. So your lordship kindly pass the same order. Your lordship.
All right. Same order.
Yes. 11/504 of 2020. 2000.
Right.
Yes.
Right. Same order.
Grateful.
Weekly list item number 36.
None appears this was an opposition.
Weekly list item number 37.
It was 37, this is a PLA matter assigned to single bench.
All right. If concept the petitioner states that this is a single judge matter, list with the roster bench on 17th October.
Weekly list item 38.
38, I am appearing for the opposite party number 9, Security Exchange Board of India.
All right. None appears. Dismissed or not possible.
Weekly list item 39.
No, item 39. The issue is whether the petitioner's company shall be charged under commercial category or under medium industry category. Earlier, he was charged under the commercial tariff category, but after he filed an application, can stated on to page 34.
You have deposited some 2 lakhs, you have to be
Yes.
But receipt is not there. No receipt is there. That's the noting. For your deposit of 2 lakhs.
Yes, I have. Sorry, I am not filed, but I have deposited. I have deposited.
No. Where is the receipt?
Receipt, my lord, I have not filed, but I have deposited. My lord.
Lords, if I may point out, my lords, similar issue was there before your lordships, and your lordships are heard and dismissed, my lords. Similar issue I may submit, my lords. The judgments, my lords. There also they challenge the tariff policy regarding change of the category. That was, my lords, dismissed. Is it relating to similar issue?
No.
Just see the orders, sir.
Yes.
Subsequently, my lords, his category has been changed.
He's also a prawn hatchery. You are also prawn hatchery, sir?
Same, my lord, same petitioner. Prawn hatchery, my lords.
No, my lord. Oh, no. The issue is different here. Man. Not the same issue. This is with regard to tariff policy, the earlier matter.
No. You're also saying that you should not be in the general category, right?
No, my lord. No, not the same. The same issue. No. This is without special tariff. I am permitted to place my documents. I can come to page 34. Earlier, I was billed under the commercial tariff, and I made an application saying that I may be billed under the industrial category. My lord. Can you come to page 34, my lord? Annex 5.
Yes.
Only I saw the 3-4 documents, my lord. Can you come to page 34, my
lord? Yes.
This is a letter written by Grid Opposition in inviting reference to a letter cited above. Mr. Dipson
industrial is less than commercial in terms of money.
Yes, madam. Yes, madam.
Charge is less for industrial.
Yes, madam. Yes, madam.
Oh.
Malaka, Dipson Hatchery Limited Gopal be allowed to be billed under industrial tariff as against a commercial tariff claimed earlier as per the provisions of IPR. But next, can come to next page. In terms of this letter, an agreement was executed. Page 35, Annex 6. And my lord, kindly come to page 38. I was allowed to bill page 38. Tariff schedule for medium industry.
Yes.
As I was allowed to bill under medium of the industry category, my lord. I'll kindly come to page 42. While this agreement was in substance, they raised me on a bill, my lord, on the top, tariff applicable to commercial category. 1, 2, 3, 4th line, my lord. Commercial. They raised a bill on commercial. Though this agreement was in existence. My lord, kindly come to next page at page 49. 49, my lord. There was an inspection by the electrical inspector, and his report is at page 50. With regard to my industry, my lord. The installation has a connected load of so and so, motor load and balance load is other types of load. As the major load is of electric motive load, and as seen from the installation that it is a medium industry as per the meaning of medium industry category classified in Chapter 7 of the OERC Regulation 3 of 98. The division has also executed agreement on medium industry category, but the bill is being prepared on commercial tariff. Hence, the bill may be revised from the date of agreement on medium industry tariff as the power is directly used for production of shrimp seed, and accordingly the ED may be revised and here is from the consumer. Mala, kindly come to page 53. There was a, it's not 53. Page 94. I raised a dispute before the GRF, and GRF dismissed my application, and thereafter I preferred the appeal before the ombudsman. Madam. Ombudsman at page 98 framed the issues, and his opinion, his finding, it has page 104, madam. I'll go to page 104. The opinion of the ombudsman, madam. Paragraph 2. Madam, got it? I shall read.
Yes.
Although, second paragraph, madam.
Yes.
Although the agreement dated so speaks in its clause number 7 that the tariff and conditions of supply mentioned in this agreement shall be subject to any revision that may be made by the licensee from time to time, and the respondent has felt the category of tariff was mentioned in the agreement erroneously and classified as the tariff suo motu. The licensee should have acted to reclassify the petitioner's category by implementing Regulation 82 of OESA Distribution Condition of Supply Code 1988, hereinafter to be read as Supply Code. But in this case, the respondent has reclassified petitioner category without following OES regulation, which is illegal, arbitrary, bad in law, and contrary to the rules and regulations. The Regulation 82 says, 82 I have quoted at page, come to the page 12 of the writ petition. I have quoted it. 82 says, as page 82 of the writ petition.
Yes.
Page 12, 82. If it is found that a consumer has been classified in a particular category erroneously, or the purpose of supply as mentioned in the agreement has changed, or the consumption of power has exceeded the limit of that category, or any order of reduction or enhancement of contract demand has been obtained, the engineer may reclassify him under appropriate category after issuing notice to him to execute a fresh agreement on the basis of the altered classification or modified contract demand. If the consumer does not take steps within the time indicated in the notice to execute the fresh agreement, the engineer may, after issuing a clear 7-day notice, show cause notice, and after considering his explanation, if any, may discount the power of supply. But in this case, the agreement is subsistence. If he wants to change the category from commercial to the medium industry to the commercial category, in that event, he has to issue a notice. They're not done that. And the ombudsman has clearly opened that. Without issuing notice, they have to change my category.
Yes.
That is my case, madam.
No, sir.
And another is that section 8, regulation 80J, it says, I have also quoted it in paragraph page 16. Page 16, madam. Medium industry class, this category relates to supply of power for industrial production purpose with a contract demand of 22 kVA but below 110 kVA, where power is generally utilizing motive force. And the electric inspector has opened that.
All right.
No, my learned friend has only referred those paragraphs that are in favor of that.
It's okay. You refer to other paragraphs, no problem.
My lords, in page 104 for a moment, my lords,
Yes,
kindly my lords may refer to. The subsequent para is also important that my learned friend read, that the respondents in their reply mentioned that they had made an error in mentioning tariff schedule of medium industry in place of commercial in agreement dated 16/3/1999, which was rectified by serving a revised bill on 21/1/2000, keeping the tariff under commercial category without executing a fresh agreement. At that time, he has challenged. Then subsequently, the respondent has also taken similar action in changing the tariff category of the petitioner from commercial to allied agricultural activities consequent upon the change of supply code by regulation 85-2, when the regulation code of 2004 came into force. That thereafter the category allied agriculture activities came into being, and the petitioner was already changed to allied agriculture activities from commercial matters. At that time also, it did not raise that regarding executing fresh agreement. And my lords, as per regulation 85-2, without executing fresh agreement.
Change the category. That's a short question, please. After saying he is industrial unit under industrial category, how can you unilaterally change it to commercial? one fine day without notice to him.
My lords, Ombudsman and GRF has categorically also observed, my lords,
That is after
agreement
going. After going to those fora, they have said he cannot be charged commercial.
Only mistake is that in 1999 agreement when it was executed
There's no
between the
mistake, sir. If you have to, there's no question of mistake. If you have to revise, you follow a procedure. That's all.
My lord, subsequently it was revised, my lords.
Without following a procedure, this is the whole problem.
My lord, subsequently when also thereafter in 2008, after coming into force of code 2004, he was again subsequently changed to allied agricultural category. That time also no agreement was executed, my lords.
No, but two wrongs don't make a right.
That is right, my lords. But my lords, subsequent to the IPR 1992, that was withdrawn by the government. No subsidy also could be, my lords,
Anyway, changing his category from industrial to commercial required you to hear him, inform him, and then do it.
My lords, regulation has to supersede over any instruction of the electrical
This is a
inspector.
question of natural justice.
My lords, they are
Something
only
adverse to him is being done. He's going to be, because you change his category, he has to pay more as electricity dues. How can you do it without hearing him? That's the only question.
My lords, the electrical, they are only relying upon the electrical inspector's report, my lords.
Yes.
So electrical
What
inspector
else?
has
He's
no
your
jurisdiction.
electrical inspector.
My lords, we have also stated the electrical inspector has no jurisdiction to define the category, my lords.
No, not for define. He's only looking into the records. He's seeing that you have granted him a connection on the basis that he's industrial. So he says, so how come you have not raised the bill on that purpose? You're raising a bill because on commercial basis.
Well, initially, the petitioner was categorized under commercial category, my lords. In 1994, since 1994, my lords.
All right. Challenge the present petition. Is to order dated 30th June 2012, passed by the Grievance Redressal Forum (GRF) Berhampur in GRF case number 136 of 2012, and the subsequent order dated 27 September 2012, passed by the Ombudsman Roman 2 Bhubaneswar in Consumer Representation case number OMB (2) S-07 of 2012. The background facts are that petition number 1 is a company having an hatchery at Gopalpur MC, District Ganjam, engaged in the manufacture or production of, engaged in the business of production of shrimp seeds. Full stop. Petition number 2 is its managing director, (MD). On 11th November 1994, the petition number 1 entered into an agreement with the Orissa State Electricity Board (OSEB) for supply of 60 kW power to its prawn hatchery for commercial production within the provisions of the OSEB General Conditions of Supply Regulations 1981 (1981 regulation). The commercial production of the hatchery of petition number 1 commenced on 9th March 1996. And a certificate to that effect was issued by the District Industry Center. Full stop. On 5th June 1997, petition number 1 wrote to the Chief Engineer (Commerce Grid Co. Orissa) to treat its unit as an industrial unit. On 25th August 1997, the petitioner, that is the executive engineer, the opposite party number 1, that is the executive engineer, Ganjam North Electrical Division, Berhampur, received a letter from the superintending engineer, Gridco, stating that the application of petition number 1 had been allowed and it has to be billed as per the industrial tariff instead of commercial tariff. Stop. On the above basis, an agreement was entered into on 16th March 1999. A fresh agreement was entered between the petition number 1 and Managing Director South Co for supply of 90 kW power for industrial purpose under the category of single quotes medium industry unquote. Paragraph. However, to the surprise of petition number 1, it received a bill for the period April to December 1999 on 21st January 2000, whereby the electricity bill was in the sum of rupees 94,709.90, treating the unit of petition number 1 as a commercial consumer. So the remark, open quotation, IPR concession withdrawal from 4/99 onwards, would stop revised from 4/99 to 12/99. Paragraph. After the petitioner's representation, the petitioner then represented to the petitioner. Sorry, the petition number 1 represented to opposite party number 1, requesting for revision of the bill by treating the petition number 1 as a medium scale industry as per the Supply Code of 1998. Sorry, as per the OERC Distribution Code 1998. Paragraph. It is stated by the petitioners that on 11th December 2000, without prior notice, opposite party number 1 disconnected the power connection and it had to sustain huge losses. Paragraph. On 11th May 2001, the Assistant Electrical Inspector Berapur inspected the unit of petition number 1 and submitted a report on 14th May 2001 stating that petition number 1 was a medium industry in terms of Chapter 7 of the OERC Distribution Code. And therefore, the bill had to be revised on that basis from the date of the agreement. Stop. Paragraph. This was, however, not done. And on 11th June 2001, opposite party number 1 issued a letter to petition number 1, directing it to pay rupees 148,848.90 in 2 installments. On 3rd July 2001, the MD of opposite party number 1 issued a letter to petition number 1, rejecting its claim to be treated as a medium industry. Paragraph. Agreed by the above letter, the petition number 1 filed OGC number 8640 of 2001, which came to be disposed of on 13th February 2012. Permitting the petitioners to file an application for the GRF. Paragraph. On 30th June 2012, GRF disposed of case number 136 of 2012, rejecting the claim of the petitioner. Paragraph. The petitioners then went before the Ombudsman -2 who inter alia held as under page 10 of the petition, para Roman small 5. Paragraph. This court has heard the submissions of Mr. Sarangi, learned counsel for the petitioners, and Mr. Mohanty, learned counsel appearing for the opposite parties. Paragraph. At the outset, Mr. Mohanty sought to contend that the present petition was covered by the order dated 13 August 2001, passed by this court in petition civil 11934 of 2013, bracket Messrs. Deep Sun Hatcheries Limited versus Orissa Electricity Regulatory Commission, bracket. Paragraph. However, on a perusal of the above decision, the court is of the view that it is distinguishable on facts. So the issue arising in the present petition, namely whether the petitioner's number one's category could be unilaterally changed from medium scale industry to commercial without any prior notice to the petition number one was not a question that arose in that case. Paragraph. Counsel for the opposite party number one was unable to deny that the inspector who visited the premises submitted a report on 14 May 2001 stating as under. Take from page 50 the highlighted portion. Since it is a report by the opposite party number one itself, there is no means to doubt its correctness. Full stop. No explanation is offered as to why the petitioner was suddenly treated as a commercial industry. So clearly because at one stage it was classified as an agri. What is that? Agri industry.
Allied agricultural category.
As allied agricultural category.
In 2000, since 2008, my lord.
Will not automatically result in the billing category being converted from industrial to commercial. Stop. In any event, that change could not have been made unilaterally without notice to the petitioner. Paragraph. For the aforementioned reasons, the court sets aside the impugn orders of the GREF and the Ombudsman and directs that the petition number one will be obliged to pay its electricity bill on the basis of it being a medium-sized industry, and on that basis to pay the industrial tariff and not the commercial tariff. In the event that opposite party number one seeks to revise the category hereafter, will do so only in accordance with law after notice to the petitioner.
Are the payments already made may be refunded or adjusted towards the future bills?
The payments, the differential of the payments already made will be adjusted against future bills of the petition number one. The petition is disposed of in the above terms.
Weekly list item number 40.
Item number 38, my lord. That is a disinvestment matter, my lord. But in rejoinder affidavit filed by the opposite party number 7 and
who are you appearing for?
I am for petitioner one. There is a letter that at present there is a no proposal in this ministry for strategic sale of Government of India's equity in Alco. So in view of the letter dated 2nd July 2000 may be disposed of.
No, you don't want to press it. You say you don't want to press it. You're not pressing the petition.
My lord.
Counsel, the petitioner states in view of subsequent developments, he's not pressing the petition. It's dismissed as not pressed. All right.
Liberty.
For what? There's no liberty, sir. All right.
Weekly list item 40.
My lord, the brief has been transferred.
All right. Counsel, the petitioner states the brief has been transferred from them. None appeals to the petitioner dismissed not possible.
Weekly list item 41.
None appeals dismissed not possible.
Weekly list item 42.
No instructions. No instructions dismissed.
Weekly list item 43. Item number 43.
43. 43. What? Lord, it's a proceeding arising out of OEA Act, Orissa State Abolition Act. Lord, in a very nutshell, the dispute projected before Lordship is that Lordship may kindly see the genealogy I have given in the body of my writ petition. From that, I can just take your Lordship to the facts and page 7. Page 7 of my writ petition.
Who's for the opposite parties?
Lord, notice has not been issued till date.
Oh, 10 years.
Lord, I have applied for substitution. One petitioner is dead also in the meantime. Sole petitioner is dead. I have applied for substitution.
Which is 13256. No, that's delay. 13255. So 13256, the reason stated the delay is condoned. 13255, the reason stated that the application is allowed. And the legal representatives of the sole petitioner, who are the 5 applicants, are directed to be substituted in this place. The amended cost title will be filed within 1 week. There's a large number of opposite parties, right? So many private opposite parties.
Lord, the Lord, number of opposite
27.
parties there. Private opposite parties, number of opposite parties are there.
26.
All right. Notice
number
Mr.
2 to 27.
Yeah, Mr. Ishwar Manti, learned counsel appearing for the opposite party number 1 accepts notice. Notice allow issue to opposite parties 2 to 27. Okay. They're all in the same place, or some different places.
It's a dispute relating to property. So obviously they have to be there.
Returnable 21st November.
But I'm taking out notice, madam.
Yes.
Great.
Weekly list item 44.
No instruction.
No instructions.
Weekly list item 45.
Number 1 is unilateral.
Not pressed, my lord.
Appearance of
Item 45 not pressed.
Not pressed. Right.
Weekly list item 46.
None basis is not.
Weekly list item 47.
46. For OP4, madam.
All right.
No.
Item 47.
I'm for opposite party number
7.
for 3. Item 46.
47.
None basis is not possible.
Weekly list item 48.
May I please, your lordship? This is a resumption of land, my lord. Under the OGLS Act, the 3B proceeding was initiated, my lord. That petitioner is the purchaser. He has purchased the land way back in the year 1985. And thereafter, the resumption proceeding was initiated, but no notice was whatsoever was issued below.
Before the order says purchase.
Impugned is appellable one.
In some cases, the matter is remanded to the additional Tahsildar to hear, or your lordship can direct him to file appeal against that. Because
No,
that
let
is
me go back to Tahsildar only.
Yes.
Yes,
Correct.
yes.
On the short ground that no notice was issued to the petitioner, who had already purchased the land in question from the original lessor by a registered sale deed dated
30th 495 below.
30th April 1995. The impugned order dated 30th June 2003.
Additional
Tahsildar Bhubaneswar in WL case number 1421 of 1974 is hereby set aside. The said WL case number 1421 of 1974 will now be listed before the Tahsildar Bhubaneswar on 26 September 2022, on which date the petition will appear along with the downloaded copy of the order. After hearing the petitioner, the Tahsildar will proceed to dispose of the said case in accordance with law within a period of 4 months thereafter. Till such time, the interim order. No, till such time status quo shall be maintained vis-a-vis the land in question. The petition is disposed of in the court.
Obliged, my lord. The next one is another purchaser. Order impugned is same.
Same.
Same order. Only the date will change of the sale deed.
Weekly list item 50.
None appears. This is the number.
Weekly list item number 51.
Let's have instructions that the appeal is still pending. Let's say I'm ready and willing to pay the pre-deposit of 25%, which the learned tribunal has directed.
You're not pressing the petition then. Counsel, the petitioner says that the petitioner is now willing to pay the.
There's one short prayer, my lords. The learned tribunal may be directed to dispose it of expeditiously.
Or willing to comply with the condition imposed by the appellate authority. Appellate tribunal for entertaining the appeal. In that view of the matter, no further directions are called for in the present petition. The appellate authority is requested to dispose of the appeal. The tribunal is requested to dispose of the appeal as expeditiously as possible, and preferably within a period of 6 months from today. The interim order passed with this court on 8th February 2013 is hereby vacated.
It's my name may be reflected by the petitioner, Pratik Das. The petitioner.
All right.
I am appearing for the opposite.
All right.
Your Lordship, on behalf of Mrs. Pamirat, our name may be deleted.
All right. Delete the name of this sponsor.
Much obliged.
Item 52.
None appears dismissed and opposed.
Weekly list item 53.
May I please, Your Lordship? My Lord, I am appearing on behalf of Mr. Ramdas Achari. My Lord, in this case, the opposite party number 4 and 6 are dead, and we could not file the substitution petition because we could not get instruction from the client regarding the legal heirs. So matter may be adjourned to.
No, you can't adjourn it, sir. The notice is not gone, I think. What's the matter about? Tell us.
My Lord, this is about challenging the order passed by the Assistant Commissioner of Endowment, Orissa, Bhubaneswar.
Yes, yes.
And that is OA number 6 by 1999.
Yes.
In the order of Deputy Commissioner Endowment.
Tell us what it is about. Why should we issue notice? You're not ready. You pass it over. You study and come back. Pass over.
Weekly list item 54.
Item 54, I am appearing for opposite party, LIC, my lord.
None appears. Dismiss and orders.
Weekly list item 55.
None appears for the petitioners. Dismiss and orders. Both matters.
Weekly list item 56.
56, my lord, no instruction from the side of the petition.
Dismissed.
Weekly list item 57.
57, the limited grievance here of the petitioners is that they are purchasers of some flats and duplexes in a project which is approved by the Regional Improvement Trust, Jharsuguda. If your lordship kindly just see one page of my repetition, that is at page, the place stay in Milord. Milord, for the entire residence, a clubhouse was left to be constructed by the developer. Milord, that is it was the extreme bottom of this page. 11,989 square feet of space was left for the clubhouse with the benefit for the public. I mean the residents there, those who have. Now in violation of that approved building plan, he is trying to raise construction of shopping complexes there. Therefore, that's the reason we came before your lordship and approached your lordship complaining about this inaction of the authorities. That the Regional Improvement Trust authorities, they are supposed to act in terms of section 150 of that act, which they are not acting, also the municipal. Lord, the private opposite party developer having appeared, they have filed a counter. In the counter, they have taken a stand and given photograph that they are in fact constructing the clubhouse, not the shopping complex as alleged by me. That's the stand they have taken in para 4.2, para 4.3 in their counter. Lord, but the photographs they have attached along with the counter, Lord, will demonstrate that in fact it's not a clubhouse. Their openings have been given for shopping and other things. Kindly see, Lord, that doesn't match their pleadings in the counter affidavit. But in any view of the matter, instead of troubling your lordship any further, lordship may direct the Regional Improvement Trust to take action on my grievance. If they find that it's a clubhouse, there is nothing. We will where our grievances are satisfied.
Who's for the club? The private opposite party? Because normally those kind of orders we pass when there is at the first hearing. Here this notice.
But there was an interim order.
Counter. Interim order status quo.
Yes, brother. As a result, this shopping complex construction was stopped. Now he is coming before your lordship and saying that I am not raising construction of shopping complex, but it's a clubhouse. But in any view of the matter, if it is a clubhouse, let some authority be directed to.
Who's appearing for Siddharth Manti? No, not Siddharth.
They are not appealing.
Siddheshwar Manti. We pass it over?
Mr. Martin. In that case, can I just seek indulgence of lordship, Lord? Sometime next week, my lord. I'm very badly placed today.
All right. None appears for the opposite parties. 5 and 6. Or even for opposite parties 3 and 4. In the interest of justice, list on interim order to continue. List on 11th October.
11th.
Weekly list item 58.
Kept it, my lord, not press.
Not press dismissed.
Weekly list item 59.
My lord, on behalf of HN Mahavat, I don't do pass over now.
Pass over.
Weekly list item 60. Item number 60.
None appears.
Weekly list item 61. 61.
61, my lord, may taken up next week because there is some defect. The second copy has not been filed.
No,
I'll file today itself. But
no, 2013 matters.
Regarding, my lord,
No, I think I hope you're appearing the right matter. 61 is 11761 of 2013. Chittaranjan Sahu.
Yes, same matter. Same matter because this is transfer brief. I have filed the Bhogalatnama. So second
counter
copy,
rejoinder all has been filed. There's no defect, nothing.
no, second copy has not been filed. That is noting.
No, that may be, sir. Let's see what the matter is about.
Regarding, my lord, the Prime Minister Rozgar Yojana. I am the unemployed young man. They have also released the money. First phase money has been received. The next phase money has not been received. Though I have also started my construction work, but due to lack of fund, I could not proceed. So, because my lord, I have to go through the brief. At least one next week it will be taken up.
No, sir. Not convenient to us. You can pass it over. You come back.
My lord. After lunch.
Item 62.
Item 62, Lordship, the grievance of the petitioner has already been redressed by the decree of the
Petitioner
competent
states that it has been rendered instruction disposed of. All right.
Item number 63.
63, my lord, no instruction.
No instructions dismissed.
Item number 64.
None appears dismissed. Not possible.
Item number 65.
65, my lord. Annexure 2 is the report of the surveyor of the municipality. He has made the spot verification and reported there has been obstruction of public road. Then, my lord, kind turn to page 11, annexure 4. That's the letter of the RDC to the commissioner of municipality. There it has been directed to municipal commissioner that you remove the obstruction as per report of your surveyor, my lord. Kindly have a glance to. Please find endorse your the petition of so and so, Katak, which he has requested to remove the encroachment from the public place as identified by surveyor of your corporation. In spite of the encroachment having been clearly delineated, no action has been taken due to extraneous conditions as alleged by the petitioner. You are requested to do the needful immediately. That's why the municipality don't take the action. As per their report of the surveyor.
Where is CMC?
I'm sorry. Because item 65, my lord. Because for CMC, I am appearing, since this is an old matter, 2013, I have received instruction. If Malas may direct the CMC that to consider the grievance, and if any there is any encroachment, that shall be taken, action shall be taken in accordance with the law.
All right.
Particular
Also,
period, my lord.
the petitioner appears in person.
It will suffice.
Refers to a letter dated 2nd July 2013, written by the Revenue Division Commissioner to the Cuttack Municipal Corporation, to the Commissioner, Cuttack Municipal Corporation, CMC, on the petitioner's grievance petition as under. Reproduce the whole letter. Counsel appearing for CMC states that if a time-bound direction is issued to examine the grievance of the petitioner and take corrective action, it will be complied with. Paragraph. Accordingly, a direction is issued to the Commissioner CMC to examine the grievance of the petitioner, particularly in the light of the above letter of the RDC, and remove the encroachments as pointed out by following the due process of law. The exercise be completed within a period of 3 months from today. And the petition is disposed of.
Weekly list item 66.
66, order of recovery under Annexure 6 is under challenge. My limited power is I'll pursue my remedy by filing with the representation is also pending under Annexure 3. I'll pursue my remedy before the opposite party number 2 and 3, Your Lordship.
Anyone appearing for 2 and 3?
My lord.
My lord. My lord, I have instruction to appear in this matter.
All right. Which is the copy of your letter?
My lord.
(1810-2012).
My prayer number 5 at page number 11 is also to consider my grievance. Page 11, prayer number 5.
All right. Counsel to petitioner states that the petitioner will be satisfied if a direction is issued to the opposite party number 1. That is the Chairman Paradip Port Trust.
Lordship, 2 and 3.
Sorry?
2 and 3 because 3 has issued the order of recovery.
Okay. Chief Engineer Paradip Port Trust. Chief Engineer bracket Electrical and Mechanical bracket and Chief Engineer bracket Civil, Paradip Port Trust, to examine the grievance of the petitioner, taking into consideration the views expressed by the Chief Engineer, Executive Engineer, E&CM Division PPT, in his letter dated 12th October 2012, bracket Annexure 5, bracket within a reasonable time fixed by this court. Paragraph. Accordingly, a direction is issued to opposite parties 2 and 3 to examine the petitioner's grievance in light of the above letter dated 12/10/2012 of opposite party number 5. and after hearing the petitioner to pass a reasoned order, not later than 1st November 2022. The court clarifies it has not expressed any view in the matter. The petition is disposed.
Deeply obliged. My name may be recorded. P.S. Acharya.
All right.
Weekly list item 67.
67 matter assigned to honorable single bench.
Single bench matter.
Challenging the order passed by the
Petitioner
human
pointed out
rights.
it is a single bench matter. List before the roster bench on 12th October.
Weekly list item 68.
May it please your Lord.
Yes.
Well, as the issue involved here is squarely covered by the full bench judgment. Lordship, remember that audit visit report has to be submitted within 7 days. And that has not been submitted. And on the other hand, the counter said they have stated that it is directory. So I think Mr. Mishra will not oppose me. He will agree to that effect.
Both matters, is it?
Well, yes, both.
Your Lordship, my only submission, this is covered, Your Lordship. My only submission is that, basing on the audit report, there are 3 writ petitions have been filed. One is under Overhead Act, one is CST Act, one is ET Act. Let me.
Yes.
One is ET Act. So far as the Overhead Act is concerned, that is WPC number 23,000.
Yes, I did press it. That doesn't mean I'll not press this one.
23,065, 2013.
Okay.
That is Overhead Act, Your Lordship. And that writ petition has been adjourned to avail alternative remedy. And in the meantime, I think that alternative remedy has already been disposed of.
Well, that is under the Overhead Act.
Your Lordship, same audit report.
Same audit.
Same.
But these are 3 different acts. Each operates under different fields. ET operates in entry tax that when goods are purchased outside the state and enters into the local area. And CST operates when there is an interstate purchase. VAT is inside the state. Let's remember that 39 ITR, that Partnership Act, Income Tax Act, and they operate this way. I don't remember the name of the judge, my lords. But there the Supreme Court said that when there are 2 acts and HUF, Hindu law, that 3 different acts operate in 3 different fields. And page 3 of the counter affidavit may kindly be seen, my lords.
Your Lordship, same here.
Yes.
And same date of order. Order is on the same date.
Muskil loko. At that time, my lords, the full bench, of course, was not constituted and the historic judgment didn't come. and now, my lords,
what happened to all these writ petitions? They're all put before the roster bench, no?
Your Lordship, roster bench has already passed the order. My Lord and Senior is also, in Kanakdhara mining also, my Lord and
Senior. Which will be disposed of in light of Jindal.
Kanakdhara mining came before my lords. And my lords, following this full bench, has been kind enough to dispose of in that line.
All right. You say in light of the judgment of the full bench dated.
Your Lordship, can I submit that Kanakdhara mining?
Yes.
Your Lordship.
Kanakdhara mining, yes. I have also got the copy.
Dated 31st March 2022 in Writ Petition Civil 16957 of 2009 bracket versus Pal Construction versus the Assessing Authority Bhubaneswar 1 circle bracket. And the consequent order dated 18 April 2022.
This is, Your Lordship, this may be appropriate for CST. Your Lordship, also the Kanakdhara CST is there.
Yes. The next matter, it is 23408. The next one is 23409.
Right.
CST Act. Same.
Well, I'm submitting order on your behalf.
Very good. But I have not got fees.
And consequent order dated 8 December 2021 in Writ Petition Civil 23871 of 2014. Read with the judgment in Jindal Stainless Limited versus State of Orissa 2012 54 BST 1 bracket Orissa. The impugned assessment order. Impugned notice or assessment order? Assessment order.
Assessment order in 23408 is Annexure 1 at page 6.
Bracket Annexure 1
at page 6
is hereby quashed. Likewise, in 23409 also, Annexure 1 is hereby quashed.
Yes.
All right.
Your Lordship may direct my Lord and Senior to give me fees because I have submitted order on
Matters, the difficulty in these old matters when your Lordship is kind enough to list it. When we write before that to a client, the client says, you argue well, money will follow. But that never happens. Much obliged, man. Much obliged.
Weekly list item 69. 69.
Item 69 infractions, my lord. Permitted to be withdrawn.
All right. States it's become infructuous. It is post of this.
Weekly list item 70.
May I please Lordship, my lord? The composite order of Lornet Tribunal on the challenge minors, Annexure 1 minors. The first part of the order minors relating to appropriate government that has already been decided by this honorable court against me. So there is nothing left for adjudication as the first part is concerned, my lord.
All right. Yes.
And the second part, my lord, that writ has not come actually. Another writ petition there that has not tagged to this one. So there are two writ applications.
Okay.
First writ application relating to appropriate government that has been decided against me. So
No. So this 25767 is the first writ petition.
Yes, my lord.
So only that is listed here.
Yes, my lord.
You see, counsel, the petitioner states that the question raised has already been answered against the petitioner. And therefore, he does not wish to press this writ petition. So accordingly, dismissed is not pressed. All right.
Weekly list item 71.
None appears dismissed or not possible.
Weekly list item 72.
May I please, my lords. Lords, this is a content application. Originally, the petitioners, your lordship may kindly say page 31, the order passed by this honorable court in the writ application, page 31. This honorable court was of the view that the grievance as raised by me in the writ application was available to be raised in the contempt application, therefore granting me liberty to file contempt.
Anyway, they filed a show cause affidavit, sir.
Yes, my lord.
Copy has not been
Show cause affidavit.
They already complied with.
How can I serve copy to you? You are then government advocate. Now you are the private lawyer on the day when
served on some of my associates. Let my learned friend serve a copy of the show cause affidavit.
Sanctioned the amount of 42 lakhs, 42,000.
Everything has been complied, my lord.
Yes.
So let me see that. Let me obtain instruction from my clients.
All right. A copy of the show cause affidavit be served on counsel the petitioner today itself. List next week.
Let the matter be called 2 weeks after.
10th.
Weekly list item 73.
Let it be called on 10th of August.
10th October.
August. You serve it to him today.
Okay.
Item 73.
None appears dismissed or not possible.
Weekly list item 74.
None appears dismissed or not possible.
Weekly list item 75.
None appears dismissed or not possible.
Weekly list for admission item 76.
None appears dismissed or not possible.
Item 77.
As your lordship, it is Chingudi prawn farm. Illegal. This your lordship, matter is like this. These prawn mafias, they are excavating the big tanks and prawn going business of prawn culture. Your lordship, on the edge of the river, 3 rivers were mixed in the Bay of Bengal. Your lordship, water is polluted.
There are enough PILs on this. We are already dealing with these matters.
It is a very good cause raised by my learned friend. Let it be tagged with that. Prawn Gheri.
That is coming on.
Prawn Gheri matters.
That is coming.
Yes.
11th.
That is coming on 11th of August.
Okay, list on 11th August. All right.
Weekly list item 78. Item number 78.
No instructions disposed.
With a liberty.
What liberty? Nothing, sir. Dismissed. All right.
Vehicle list item 79.
None appears dismissed. No first question.
Vehicle list item 80.
My lord, on behalf of Mr. Mohanty, today he was not present in some personal inconvenience next week.
What's the matter about, sir? Let's see this. ROR, DIL. To save the land, the purpose of pasturage, demonstrate illegal construction.
In fact, he has submitted a representation.
I think that's the best. The petitioner's representation. Annexure 2.
Let him submit a fresh representation to the Tahsildar because it has been addressed to the collector.
All right. You say a fresh representation, permitting the petitioner to raise a fresh make a fresh representation to the Tahsildar.
Yes.
Jatni, bracket opposite party number 3. And after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Vehicle list item 81.
Memos taken on record, dismissed as infractions.
Item 82.
My lord, may I please be my lords. My lord, this PL is pertaining to the Mental Health Care Act that 2017, my lord, and state inaction, my lord, because of which persons who cannot take care of themselves are roaming around on the road, naked even, my lord, and are not being rescued by police authorities, citing reason that the person was already rescued earlier and was subjected to treatment, and then thereafter the person is roaming on the road.
Do you have any specific instances?
Because no facilities available to keep such persons.
So do you have any specific instance of any such person?
My lord, a few days back, my lord, I came across one person.
Not like that. You have to point out in your petition. Have you drawn the attention of the court to any specific instance?
No, there is no.
My lord, I had submitted annexure to my lord, two before the Secretary, Department Health and Family.
Sir, are you following the question?
My lord.
Just asking the question. I think he's not following what I'm saying.
Have you had any instances so that it can be brought to the notice of the court?
My lord, a few days back, my lord, I came across one person.
Not like that, sir, in the petition.
Not my lord, that I have not mentioned.
So you may want to bring in specific instances, sir. Permitting the petitioner to file a fresh petition, make a fresh representation to the authorities, drawing their attention to specific instances of non-implementation of the Mental Health Care Act. The petition is disposed of. And after following up on such representation to seek appropriate remedies, the petition is disposed of. All right.
Vehicle list item number 83.
No instructions.
No instructions. Dismissed.
Vehicle list item number 84.
Pass over.
All right.
Vehicle list item 85.
May I please? My lord, in this case, my lord, the petitioner challenged the illegal and arbitrary action of the opposite party with regard to non-taking of any action against the illegal sawmills which are running by opposite party number 9 to 30, my lord, in the district of Baleshwar, my lord.
Representation.
Yes, my lord, Annexure 3, my lord.
All right. Annexure 3 series.
Annexure 3 series
shall be examined by the opposite party number.
Opposite party number 2, my lord.
2. That is the principal chief conservator forests. Bracket of opposite party 2. And after issuing notice to the petitioner as well as opposite parties 9
to 30, my lord.
9 to 30.
Yes, my lord. They are operating that illegal sawmills.
And after giving them a hearing to pass a reasoned order not later than 19th December 2022. The court clarifies it is not expressed anywhere in the matter. Copy the order be made available to the parties within a week thereafter.
Possible. Weekly list passed over matter item number 6. Item number 6. Item number 6, WPC 4836 of 2006.
He's a lawyer. Okay. None appears despite a passover. Dismissed for non-prosecution.
Weekly list item number 12.
I may please your lordship. My lord, the annexure 7, the representation of the petitioner is not being considered, my lord. Annexure 7, he has edited all the grievances of my lord. My lord, the grievance of the petitioner, my lord, his service was regularly as process server, my lord, in the year 1993. Thereafter, that was being extended from time to time, the engagement. But on after 15/5/93/95, there was no extension after annexure 3, my lord. And even though he was discharging his duty, thereafter on 25/8/1995, again the order was extended. And for that 3 months, my lord, is not getting salary nor an increment.
How can you come in 2011 for something that happened in 95? 16 years. What were you doing for 16 years?
Gradation list he has talent, my lord. Gradation list. His grievance is to.
As my instructions are that his grievance has been redressed, and in fact, Milord's a revised gradation list has been prepared, placing his name, and he has already been promoted and posted as process server in the Court of Civil Judge, Junior Division, Jajpur, as per order number so and so, dated 23/6/2012 of the District Judge Cuttack. So,
I see. So, counsel for the opposite party.
My lord, your lordship may kindly see to annexure page 19, my lord. Page 19, no termination, no disengagement, but reinstated after 3 months.
Have you heard what he just now said?
My lord.
Have you heard what the counsel for the opposite party just now said?
Said, my lord, promoted and getting salary, but the increment for that period is not getting, my lord.
You make a fresh representation for that, sir.
My lord, fresh representation.
Permitting the petitioner to make a fresh representation. If the counsel of the opposite parties informs the court that the petitioner has already been placed in the appropriate place in the gradation list and has now been promoted in the office of the
my lord, he has been posted as process server in the Court of Civil Judge, Junior Division, Jajpur.
He's already been posted as process server in the Court of the Junior Judge, Civil Judge, Junior Division, Jajpur.
Transferred.
For any other grievance, it will be open to the petitioner to make an appropriate fresh representation in accordance with law.
Now he's working at Jagatsinghpur, my lord. Now he's discharging duties at Jagatsinghpur, my lord.
Jagatsinghpur.
Yes, my lord.
This was my lord's 2012, so subsequently he might have been.
All right. Yeah.
My lord, pardon to mention the jail criminal appeal 29 of 2012. I have now submitting my written note of argument or decision.
All right.
For the appellate number 2, my lord.
Yes.
Weekly list passed over matter item number 19.
19. Yes.
19.
My lord, just now I have received instruction from the concerned BDO that one Ramachandra Mohota is working as GRS in Jamsara GP since 27/9/2021 under Bisra block.
How can that is violation of the order of the court? No?
The only way is to remand the matter and the single judge will be.
Well, that will be better. I have also transport to
Udusu Gram Panchayat, my lord.
My lord, the remand will not do
Udusu Gram Panchayat in Bishra block. And that Jamsura is already filled up. Khutuma filled up. And Ankrupali also filled up. So better to remand to the single judge so they can locate the.
Mr. Roy.
Yes, my lord.
There's somebody working in Jamsura. Jamsura GP.
But there is a stay order, my lord.
I know. I don't know how he's working. One Mahato, no?
Mahato, Ramchandra Mahato.
Ramchandra Mahato.
No, that is interim stay. There was no rest. I think I have to examine because there is no order to stay the appointment, I think.
Yes, my lord. There is some. The consequential engagement of respondent number 5 under Annex 3 shall remain stayed, my lord. That is the
5 is not Mohata, I think.
No. Mahata is not a party.
Some other person who is not a party to this case.
No. Actually, they state the order dated 3rd July 2012 and the consequential engagement of respondent 5.
Yes, my lord.
So that I don't know how they interpreting that, the stay of the single judge's order.
If they wanted to engage, they should have taken the leave of this honorable court, my lord.
That's what to do.
That is the instruction which I have received.
Then let's say that he should be accommodated somewhere else now.
Yes.
Will you be prepared to go anywhere else, wherever it's vacant?
I don't have up to date.
He can work in any Gram Panchayat, they say.
Under that district. In that district. Project Director, DRDA, Sundargarh.
All right. You see, you have to add in this. Instead of 5. So where is respondent number 5 working now?
I am in Udusu Gram Panchayat in Bishra block.
I may be permitted to place anywhere under that block only, Bishra block.
We don't know, sir. It is available. It all depends on availability.
Because I am a resident of Jamsara Gram Panchayat, my lord.
I know, but Udusu is what spelling?
DUSU, my lord. UDUSU.
NUD.
Udusu. In Bishra block, my lord.
Okay, you say?
From 2019, I am continuing.
Say, although there was an interim order passed by this court on 3rd January 2013, staying the order of the learned single judge and also the engagement of respondent 5. Mr. D.K. Mohanty, learned AG on instructions, informs the court that one Sri Ramchandra Mahato,
MAHTO.
MAHTO, Mahato, is working now as GRS
Jamsara
GP. In the Misra block.
In Misra block.
The Misra block.
Since 27th September 2021.
Of District Sundargarh since 27 September 2021. Paragraph. In that view of the matter, a direction is now issued to the project director DRDA Sundargarh to give appointment to the petition appellant as GRS in any other GP in the same block, no, preferably in the same block, but definitely the same district Sundargarh, wherever there may be a vacancy within a period of 3 months from today. The appeal is disposed of in the above. The impugned order of the learned single judge is accordingly modified and the appeal is disposed of in the above.
OP number 4
is presently posted at Ankurpali Gram Panchayat. Instead, he was earlier at Kuntagam, they are posted at Ankurpali Gram Panchayat. That will be corrected.
Audit.
Oh, bless my lord.
Right.
Weekly list passed over matter. Item number 53. Item 53.
May I please, Your Lordship?
Yes.
My Lord, no instruction.
Responsible petitioner states he has no instructions. Dismissed. All right.
Passed over matter. Item 59.
My lord, I am sorry, my lord, this item to Pastor over. I am appealing for intervener, my lord.
Intervener. All right. None appears for the petition. All right.
Passed over matter. Item 61.
Tell us.
My lord, here the petitioner is an unemployed young man selected for availing the Prime Minister Rozgar Yojana, the benefit, and he was also sent for training. After availing the training, it is also directed the petitioner that he to avail the loan from the State Bank of India at Banki branch. And the Banki branch also accordingly directed the petitioner to submit all these documents, which I have also submitted that document. And first phase, my lord, the first phase loan has already been released. That was 80,000. And getting that first phase money, I construct the boundary, etc., everything. And that is, my lord, the subsidy of 3.5 lakhs that has been deposited in the bank, by which it is directed that the no interest can be also incurred neither on the petitioner, that the petitioner will not pay the interest. So far the entire matter of the loan money was 9 lakhs some odd, and they have also received it near about 5 lakhs. Only they to release 4 lakhs in my favor. Only for 4 lakhs they have also delayed. That all the documents one after another they sought for. I have also availed them. I have also given all the documents.
No. They say you have to submit NOC from pollution.
NOC I have given. NOC I have already given from the Pollution Control Board. And also the ash plant, the NALCO also given the green signal. I am providing the ash. That was also there. Despite my lord, I have giving all the documents. They have delayed the sir.
1 minute, sir. You have got para 7 of the counter.
Counter, my lord. Yes. Para 7. My lord. Okay, 7 again. Yes, my lord. That as regards the aberrament made in para 11 of the writ petition, it is further submitted that even though the project profile was also prepared in July 2008 for the said unit, whereas the consent to establish the fly wash bricks unit was received from the Regional Office State Pollution Control Board, Orissa, Cuttack, via letter dated 23/3/2011, after lapse of 3 years under Annexure 5, envisaging the several terms and conditions required to be fulfilled by the petitioner before commencing the production. Moreover, the petitioner has not yet submitted the above stated consent letter dated 23/2011 received from the Regional Office Pollution Control Board, which has been availed by the petitioner 2 years after, and 2 years after the sanction of the loan. Thus, the OP number 1 is not in a position to
then come to para 9. What they say in para 9 is they went on physical inspection
that as
found the unit closed.
Para 9.
Yes.
That as regards the aberrament made in para 13 to para 12 of the writ petition, it is only submitted by the opposite party number 1 that in view of the non-cooperation and the callousness of the petitioner, the branch manager SBI Bank branch OP number 1 was issued with a letter dated 21/5/2012 from the Assistant Director KVIC, Ministry of MSME, Government of India, State Office, Orissa, asking the bank to refund the margin money immediately, though its nodal bank, with the intimation to the office in view of the physical verification record submitted by the APIT Company Limited, Bhubaneswar, in respect to Sri Chittaranjan of the present petitioner at Kendupalli, post Kendupalli, district Cuttack, for setting up the fly ash unit at Kendupalli, financed by the SBI Banki branch, is not existing and not fulfilling the PMEGP norms. A copy of the said letter dated 21/5/2012 is annexed herewith as Annexure A for the kind perusal of this Honorable High Court. In this context, it is further submitted that on 2/5/2013, a joint visit of the bank and the KVIC officials was undertaken to the unit and to the residence of the petitioner. As he was absent, he was contacted over phone and is requested to call on the branch for discussion, but he has never turned up. Thus, the OP number 1 was forced to close his loan account, which has already been turned into NPA by debit to his savings bank account, as the establishment of unit was inordinate delay. The inordinate delay is not for the cause by the petitioner. The inordinate delay because to availing the pollution control, because the bank itself, the bank
can't wait endlessly. See, the bank is under pressure from the government of India.
But whatever
government of India gives margin money, the whole scheme is the government of India will give a margin money, bank will give a loan, you'll start the unit.
Sir,
you can't be waiting endlessly for you to start the unit.
No, we are not delaying unless and until I have already constructed. Getting an assurance from the bank that I am getting the loan. I have constructed. I spent the money also. I spent the money expecting that the second phase loan will be released in our favor.
Yes.
Let the bank to verify and also see.
Already verified, sir. The whole account has been turned NPA now. You have to do something else now. Nothing else can be done here now. You say the petitioner's grievance is the second tranche of his loan has not been released by the State Bank of India. Opposite party number 1, State Bank of India, Banki branch, for his fly ash project. In response to the notice issued in the present petition, a counter affidavit has been filed by SBI, in which inter alia it is stated that even though project profile is prepared in July 2008, the consent to establish the fly ash brick unit was received from the State Pollution Control Board, Orissa, only on 23rd March 2011. Stop. A copy of the said letter had not yet been furnished by the petitioner to the bank. So that apart, it is stated that the bank received a letter on 21st May 2012 from the Ministry of MSME, Government of India, asking SBI to refund the margin money in view of a physical verification record submitted by APITCO, APITCO Limited, Bhubaneswar. Full stop. On 2nd May 2013, a joint visit was undertaken by the officials of the SBI and KVIC to the unit and to the petitioner's residence. Full stop. He was absent and was contacted over phone and requested to call on the branch for discussion. Open quotation, but he never turned up. Unquote. It is stated in the circumstances that SBI was forced to close his loan account, and it has also already been turned into a non-performing asset by debit to his savings account, as the establishment of the unit has been inordinately delayed. Paragraph. Although a rejoinder has been filed by the petitioner denying all of the above contentions and saying that such physical verification either did not take place or took place behind his back, he is unable to deny the fact that he never went back to the bank to inquire about the physical verification that has been undertaken. Full stop. Significantly, this writ petition has been filed soon after such physical verification. Full stop. The rejoinder of the petition only raises disputed questions of fact which cannot be adjudicated in the present petition. Full stop. The petitioner will obviously have to take steps as regards the loan account being turned into an NPA. Full stop. Leaving the petitioner, therefore, to avail other appropriate remedies as may be available to him in accordance with law. The petition is disposed of. Right.
Passed over to item number 84.
May I please, Your Lord. I may bring your lordship's attention to page 24.
Yes.
Wherein the learned collector has directed to stop the construction of the road under PMGSY on over the Gochar and Jalasaya, my lord. Thereafter, after keeping mom for a period of 6 years, thereafter the Gram Panchayat has constructed the road under Monrega. And your lordship knows Monrega, in Monrega project, no masonry cannot be used. And a road cannot be used without using masonry, my lord. And your lordship may peruse.
Sir, now to ask them to remove the road is not going to be possible. What is your interest in here in this petition? This is a PIL.
Yes, your lordship.
Why are you opposing a road?
My lord, sorry, my lord.
Why are you opposing the construction of a road? Normally, people ask for a road to be constructed.
Because there is a road exists, my lord. Old road is exist. They are not developing that road. They are developing a road over the Jalasaya and Gochara land. Prior to this, this honorable court directed the collector, learned collector, to dispose of the representation, and the collector has decided in that representation that as because there is no surplus Gochar land available, if your lordship peruse page 24, I may read one para. Page 24, second para, sub-para. As reported by Tahsildar, in the event of non-availability of surplus Gochar land in the village and otherwise not alienatable of Jalasaya, the construction of PMGSY road over such land is illegal, illegally permissible, not legally permissible, which has been intimated to the executive engineer. Therefore, the executive agency of the PMGSY road, that is the executive engineer added to Cuttack, may take steps for suitable alternative, including choosing the existing village road.
1 minute, sir. This was in 2014.
Yes, lordship. They kept silent thereafter. And in the year 2020, they are again constructing the road under Monrega, my lord.
No. They are constructing, or they've already constructed?
My lord, when the writ petition was filed, they are trying to construct, my lord.
What is all this? You don't even know what the factual position is.
I could not able to contact.
And you've not bothered with this petition. It is automatically listed on its own.
Yeah,
it has not even
old.
come once.
2 years old.
He has not even moved an inch to get it listed. This is not PIL, sir. The court is not impressed with the prayers in the present PIL.
Prayer number 3 is substance, my lord.
Which was filed way back in 1st July 2020 and has not been brought up for hearing at all, even once. On its own, the matters got listed today. Full stop. The grievance of the petitioner is about construction of a single quotes Gramya Rasta, unquote, over what he considers to be Gochar and Jalasaya lands. In village
Diniari, my lord. Diniari, D-I-N-I.
Diniari.
Full stop. The petitioners also appear to be from the same village. And clearly this appears to be a difference of view among the villages. Counsel to petitioner is not able to inform the court what the current status is. Full stop. In all probability, the road in question has already been constructed. Full stop. Consequently, at this stage, the court is not inclined to interfere. The petition is dismissed.
Supplementary list. Press admission item number 1.
May I please, my lords?
Yes.
In this matter, my lord, inadvertently, 2 PANs issued, my lord, one in the name of Co and Swine and another in the correct name of Swine and Co, my lords. Immediately, my lord, by the Annex 1 at page 17, the lordship would kindly turn, my lords. In the PAN grievance portal, my lords, I registered a complaint regarding the revocation or cancellation of PAN issued in the favor of Co and Swine, my lords. And that was way back on 28th of November 2014. And my complaint number was given, my lord, Annex 1 at page 17. Nothing was done on my complaint, my lords. Then I approached the bank, my lord, on different occasions, right from 2015 onwards, to reverse the 26As and the AIS statements in the correct PAN and indicating it to be in the name of Swine and Co, my lords. As a sequel to all this, my lords, now a 148 notice was issued in the name of Co and Swine, which is a non-existent company, which is not there at all, my lords. And, my lord, now this has culminated in an assessment order under 144, my lords. And my simple prayer, my lord, would be a direction to the department, my lord, to reverse this or to revoke this PAN, my lord, to cancel this PAN issued in the name of Co and Swine, my lords.
Yeah,
I've given the 2 PAN numbers.
How can there be some name called Co and Swine?
Yes, Lord.
Lord,
he has filed a grievance, but he has not filed the correction or deletion of the as per the 49A. Lord, 49A, Lord, the section itself says he has to file an application for PAN, and if his name is for correction and other thing, he has to correct it by filing a separate form. There is 2 forms. One is correction, and one other is not available for application for new PAN. But simply, my lord, he has filed a representation for the department. Department cannot do its own. He has to file a form in accordance to Rule 114.
No, this is
second
Lord,
is not
these forms which my learned friend is now indicating is not for invalidation of a PAN, my lords. Your lordship would kindly see the grievance, my lord. So the third at page 17. Owing or using more than one PAN is against law. You may furnish information on multiple PANs inadvertently allotted to you, my lords. So this is how I'm getting a complaint number of which has been indicated, my lord, at the back notes.
But he has to file it.
Now, these applications are not for invalidation of the PAN, with great respect to my learned friend.
What is the action taken on this complaint number?
Lord,
Nothing, my lords. Because the last
on this issue, but fact remains, Lord, he has to give in complaint to the DG information, who is the looking after the PAN and other correction.
You give that complaint to him now?
No, but he has not made party, Lord. He has not made party branch manager.
All part of the department only.
No, Lord, I'll do no issue, Lord. But he has to make party because he is sitting at Delhi. He is not sitting at Bhubaneswar, Lord. He is sitting at Delhi or somewhere else, Bangalore.
Bangalore people will say Ghaziabad, my lord.
No, Ghaziabad.
A particular situation happened, my lord. When we went to Bangalore, my lord, they said that
difficulties, Lord.
We say that we are only a processing center. The entire control is at Ghaziabad. Then the Ghaziabad center said that we do not have any information.
No,
ultimately, my lord, this honorable court in a particular case directed the SBI, my lord, to reverse all these 26As and AIS statements and give the relief to the petitioner, my lords. Because there was there was a ping pong going on between Ghaziabad and Bangalore, my lords. My learned friend is also privy to that particular case.
I am applying the State Bank in that case.
My learned friend is privy to that, Lord, where the State Bank was directed to reverse all that. And these applications, Lord, is never for a revalidation of the, for cancellation of the PAN.
Lord, he is coming before this court after passing the assessment order, Lord. Kindly see the assessment order.
I have been
the expert, he has not whispered that.
No, there is no entity called Co and Swine.
So he has to submit it before the assessing authority that this PAN is not in my favor. He has never appeared. Kindly see, Lord, running plus 56 for a moment.
Your lordship may kindly see Annex 2, my lord. I write to the
intent to appear.
No, I write to the ITO Honorable, my lord, stating all the facts and my complaint dated 28/11/2014, my lord. And a copy of that
I will take instruction so far as the grievance is not absolutely correct. I will take instruction. But so far the assessment is concerned, he has to file appeal. Because he has not.
Lord, I have not once.
He is not Co and Swine.
No, he has not stated.
File appeal?
He has not stated. Notice are issued to him. He has simply silent sit over the issue. Kindly sit on
No, Mr. Satpathy. Let's say that notice is issued not to him but to some Co and Swine.
Right.
Is he supposed to appear?
No, Lord, he has to say, he has issued,
He
he
is
has
not
received the
Cohen
notice.
Swine.
He has received the notice, my Lord.
No, just the address is the same. He
No,
is
he
not
has
the
received the
entity.
notice. He could have said, my Lord, that this is not
He
mine.
has made representation after representation.
No, my Lord, I am saying, my Lord, assessment order, kindly see running plus 56. He has never appeared and not spell out that it's not my case, it's somebody else's case. After passing of assessment,
Lord, the entire issue,
to stay up the assessment or taking the view that this is this question.
Lord, the entire issue can be solved, my Lord, if this is, my Lord, cancelled and the 26A statement, my Lord, is redone, my Lord. What the bank has done, my Lord, for a few periods, my Lord, they strike it out, revise it at 0. Then again, for this particular year, my Lord, they don't do it. My Lord, if your Lordship would see, my Lord, I have given the instances where the bank itself has modified the 26A statements, my Lord. Your Lordship may kindly have a look at it, my Lord, for some years. And for this particular year, they don't do it, my Lord.
But that is not
And they say,
defect of the
Anyway, notice has to go now. But the bank is not a party here.
my Lord, the bank is a party, my
Oh, I
Lord.
see.
Opposite party number 1, my Lord.
All right. You say notice. Mr. Satpathy accepts notice for 2 and 3. Notice to 1 returnable on the next date. Say till the next date of hearing. Replies be filed within 4 weeks, rejoined up for the next date. What's the interim relief?
No, there's no interim relief prayed for, my Lords.
But
I was only praying, my Lord, subject to what falls from my Lords, my Lord. That if this particular assessment order goes, and in the meantime, if they correct it, my Lord, the entire issue can be saved, my Lord.
Yeah.
Because now Swine & Co., whatever, my Lord, interests were given in these time deposits has been shown in the returns of Swine & Co. And he has been assessed, my Lord. It's not the question of a particular income accruing in the.
It cannot be, my Lord, because
Anyway,
to file the correction, revised application before the.
Let them verify, my Lord. Let them verify. Let my learned friend verify the fact.
among the other things pointed out in the present petition is that instead of you say that an assessment order has been wrongly passed in the name of single quotes Co and Swine, whereas the correct name should have been Swine and Co. This is stemmed from a wrong PAN card being issued in the name of single quotes Co and Swine, for which the petitioner has made repeated representations, which have not elicited any response. Full stop. As a result of the above error, the Form 26A is issued by the opposite party number 1 bank have also been wrongly issued in the name of single quotes Co and Swine. Paragraph. Mr. Kerr has pointed out that the petitioner's grievance number 95113597 has not yet, complaint numbers, has not yet elicited any response. Mr. Satpathy states that he will seek instructions on the status of the above complaint. List on September 7th.
And my Lord, if your Lordship would kindly turn to page 49, Annexure 6, my Lord. Here, the entire assessment, my Lord, has to be done faceless, in the faceless system, my Lord. Because if your Lordship would kindly see point E, as such, my Lord, with great respect to my learned friend, my Lord, this assessment order as such has to go. Even though, my Lord, I'm not raising that point because it's against a wrong entity. Your Lordship would see, my Lord, E, my Lord, at page 49. In cases where the order has to be passed under section 153A or 153C of the Income Tax Act, regged with section 143.3, assessment proceeding would be conducted manually. For all other methods or sections, my Lord, it has been done faceless, my Lord. It has not been done in a 144 faceless scheme, my Lord. So as such, my Lord, this has to go in toto, my Lord.
Now, my Lord, the assessment order is passed, my Lord. It's passed with the assessment order.
Lord, if the entire proceeding, no, I'm not, with great respect to him, my Lord, this has to be done in a faceless manner, my Lord. This is being done manually.
But it will not affect anyone, my Lord. Suppose it faceless or manual. Assessment order has been passed.
All right.
Supplementary list item number 2.
Much obliged.
May I please your Lordships?
Yes.
So I'll take note. I'm sorry, Manoj. I take notice by registered post to or
Yes,
speed post. Right. The tracking report may kindly be.
Yeah, tracking report.
And extra copies on Mr. Satyajit, Manoj. Much obliged, Manoj.
Right.
Item number 2.
May I please your lordship? In this case, notice has been issued on 30/11/2021. The facts are like this, Lords. In Chilka fishery, people are earning their livelihood by fishing from particular area. And this has been, so far the petitioners are concerned, Lords, have filed documents how they are earning their livelihood from a particular area. And previously, this Chilka was confined to 2 districts, that is Ganjam and Puri. Now, after bifurcation, a portion has come to Khorda district, Banpur Tahsil. Now, what is happening? A small section of the fishermen of this area, they are now settled at in a village called Subhadrapur. They have settled at Banpur, under Banpur. Now, the Banpur Tahsildar is going out to get the entire fisheries leased out to them, so that we will be deprived of our fishing right forever. Now that without appearing in the case, they are going to, for that reason, I have filed this interim application. Till your lordships decide this, if your lordship will want, I will place one by one how, since time immemorial, I have filed the documents. A government also will not dispute how we are enjoying the fishing rights. Now suddenly Banpur Tahsildar gives our fisheries to somebody else. Not only there will be difficulties, there may be class, murder, etc., etc. So until and unless it is decided, I will pray, my lords, the Banpur may not give any lease to anybody else. That is my only prayer in the interim application.
Yes, my lord. Your lordship may kindly have a glance on prayer. Prayer at page 28 of the writ petition. Directing the opposite parties to make necessary inquiry, investigation, and settle the fish soirats which is being enjoyed by the petitioner since time immemorial. The prayer is that this soirats should be settled in their name. What has happened, my lords? This is a government soirat. They were in unauthorized occupation. They were
these are all wrong things. If I will your lordship, then permit me to place from the beginning. Then lordship may
I am submitting from their records.
Let me permit from the beginning. Making a wrong statement, I don't believe in it. Your lordship may kindly turn to Annexure 2.
Yes.
How I was wrong, I will say. Because this is a report of 1957 given by G.N. Mitra, the then Director of Fisheries. If your lordship, I am not taking, your lordship will kindly see page 32. We are the villagers of Koudi Khani, and our society is now Gadi Brahma. A mile west of Jaguliapada, on another branch of the river Daya, Koudi Khani has 71 Keutu families, which in a population of 406 male and so female. Net so and so details. Then Bodaora. These Bodaora people have a portion of them have now settled in a village called Subhadrapur. So that is creating all problems. Then Bodaora, then thereafter Jagulia Padara. If your lordship will turn to kindly page 37. Page 37. Last line. Subhadrapur 50% and villagers of Bodaora and Jagulia Padara 50%, villagers of 50% to the villagers of Koudi Khani. By this ratio, they are enjoying. Because thereafter, I have filed documents, Annexure 5 series, my lords. Your lordship may see these fisheries either by way of auction or by way of settlement from the Central Society. Now that Central Society, after the judgment of this Honorable Court in 1994, everything was controlled by Central Society. That Central Society has now been defunct. So their Central Society was giving, now they are being given by Tahsildar, by auction. In some years, they are not auction, they are collecting money from us by different means. Now, if the entire fishery is given to one villager, then we will be nowhere. I have given all the documents how we are enjoying. Not that I am saying out of my mind. These are all documents which have been given by the government. Tahsildar, then receipts, everything I have filed by annexure. I have never said this is government fishery. This is a fishery inside Chilika, which is being enjoyed by the fishermen of Chilika since time memorial. And for this reason, there was a writ application before this honorable court, and this honorable court directed, as per the 1971 policy, a society be formed, central society. They were controlling. Now central society is no more there. So for this reason, now that this has gone to a new district, Banpur Tahsil, and the fisheries have come under Banpur, they are going to be given it to Subhadrapur, then we will be nowhere. That is the only fact. If your Lordship wants, I'll place everything page by page. Only I am praying, let them appear. Till then, this may not, Banpur may not leased out in favor of your Lordship. May kindly see your Lordship's first order. Order number 3. Your Lordship, last opportunity granted to opposite parties to file reply within 4 weeks. Reason are there to, if any, be filed before the next date. No reply, no counter. And
No, we have fixed it for 12 September, sir.
Yes. No, I have not given. But in the meantime, if this is settled, then we will be nowhere. And there will be classes. And in Chilika previously, there have been innumerable murders for these fishing rights.
No, but what makes you think that they're going to grant the lease now?
Ma'am, we have made because I have said in IEA Millets, I have made the IEA Millets. In the meantime, your Lordship may say, in the meantime, Central Society has become defunct. And now they are going to give it to villagers of Subhadrapur.
No, how do you know that?
I made the Tahsildar. He said, no, it doesn't come within your area. You are now belong to Puri district. Now fishery has come to Khordha district. So you will be not given. We have met him. Met him repeatedly, my lords. That is my grievance. I have no other grievance. I am not saying that they will not
Lordship, in this case, I am having for the opposite party number 13, my lord.
Who's that? You have to switch on your camera. You're not visible.
Subhadrapur fisheries, my lords, 13.
They are your contesting party.
In this case, previously one WPC 16357 of 2010 already been decided, my lord.
Let it be tagged to that, then your Lordship may decide.
On this case, on that it has been
That's a
decided.
disposed of case.
16357 of 2010.
You have to switch on your camera, Mr. Biswal.
My lord, due to some problem.
Then your Lordship may call for that. Interim protection may be given. Let them file their counter. They have not filed their counter, nothing, my lord. If they take away the list, there will be.
If my learned senior will permit me, may I submit one?
Yes.
Your Lordship may kindly come to page 99.
Yes.
Of the writ petition.
Yes.
This is the order sheet of a encroachment case number 12 of 2021. The encroachment.
Mr. Das, you'll have to permit him to make a submission.
Yes, my lord. Yes.
The encroachment case is started against Sri Gadi Brahma so-and-so fishery Samabaya. That is the petitioner, the client of my learned senior.
Yes, I
of Mauja, Kaudi Khani, so-and-so. This is particular. Land schedule is there. Then your Lordship may kindly go to page 100. The case is, that is order dated 6/7/20. The case is taken up today. Notice was properly served and restored to the CR. The encroacher is present, absent on call. He has filed a WS stating there for settlement of the encroached land in his favor. Peruse the G. He applied for settlement. Your Lordship, there was an encroachment proceeding. Before the concerned Tahsildar, the petitioner applied for settlement in Go form. Reported peruse the Go form report of the RI Busundapur. It is reported that encroacher possesses so-and-so agricultural land and his or her annual income from all sources so-and-so. Considering the above of the encroachers, the encroached land is for the purpose of has to pay assessment so-and-so. It is reported that the sum of the encroached land is the so-and-so. Hence, issue notice to the encroacher to vacate the encroached land within 30 days on receipt of the notice. Then, page 101. case record is put up today. R.I. Bhushanpur has reported that the encroacher has vacated the encroached land. Hence, the case is closed. So what I beg to submit, this is a government soirat. They were encroaching that soirat and they are already vacated by process of law by initiation of a proceeding under the OPLD Act. Now it is to be leased out by auction. Now, I think the claim of the petitioner is that since I was there for time immemorial, the land should be leased out in my favor. That was turned down by the Tahsildar, what is revealed from your document. So that
I'm prepared to take part in auction, my lords. They are not allowing us.
I don't say that. I have no idea whether they are.
He is making a submission out of his own. They are not allowing us to go there because they say you belong to some other tahsil.
My lord, I do not know whether the auction is going to be held recently or not. But my submission is that your document reveals that you are an encroacher and you have already vacated the place. Now it is a government soirat. You are claiming that I am entitled to get a lease. Yes, your claim can be adjudicated by the Honorable Court. I don't dispute that. But how can you stop the government in dealing with the government soirat?
I am not stopping anybody, my lords. I have myself filed these documents saying that for some years there was no lease given. When we were possessing it, they took money from.
No, you are not possessing. You are already vacated. That order shows that you have already vacated.
We are there, my lords. We are never vacated.
So you are going against your own document.
My lords, your encroachment case started. For that, we have penalty and we are in possessing that land.
No,
Because
page
those
101. They have already vacated page 101.
Miller, those years they did not lease out the land as previously they were rejected.
Mr. Das will issue notice on your application. If there is an auction, we'll say it will be subject to the outcome. If there is an auction.
No, if there is an auction,
that is more than enough for you. If there is an auction, it will be subject to the outcome, but we don't know if there is an auction.
No, Miller, if there is an auction, they will permit us to participate. We are prepared to.
That I think nobody can stop it if he wants to participate. That is my personal opinion that nobody can stop anybody from participating in the auction.
But they are not allowing. Tahsildar is not allowing.
Unless you are eligible for that purpose. The eligibility criteria are there. If he is not eligible.
If your lordship permit me, I am prepared to take part. I was from time immemorial, I am fishing in that area. I am prepared to take part in auction. I am not saying settle it in my favor.
All right.
So he's not pressing the
Just listen to the order.
So
IA number 9929 of 2022. Mr. Shaktidhar Das, Senior Counsel appearing to the applicant, apprehends that the Sairat in Banpur, Tehsil is it or Taluk? What is it? Tahsil will be given away on lease to
OP number 13.
OP number 13, that is village Subhadrapur. And that the petitioners who belong to the three villages of Kaudi Khani, Badawara,
Padara and Subhadrapur. I have shown Millers.
Kaudi Khani
and Subhadrapur.
Jagule Padar and Badawara will not be allowed to participate. Paragraph. Mr. D.K. Monthil at AGA states that he will have to seek instructions on whether at all any auction is being held.
Or it is settled otherwise.
Or it is, or the Sairat has already been settled. So in any event, you say notice, you say Mr. Mohanty accepts notice. Have you served a advance? Yes, Mr. Biswal.
Yeah, my lord.
Do you have a copy of this application?
No, my lord.
A copy of this application be served on Mr. Tapan Biswal, who's appearing for opposite party number 13.
I will serve by tomorrow.
It is directed that if no auction has been held as of date, status quo will be maintained till the next date. If it has already been held, then it will be subject to the outcome of the further orders passed by this court.
Semi listed along with you WPC 163.
That's right. Sorry, WF?
WPC 163.
163?
5/7/10.
No, is it a pending petition or disposed of?
My lord, it is disposed of with the direction to the Tahsildar Tangi, my lord.
So it's a
To
disposed of
detach
case. Just
actually,
record of writ petition civil 163
5/7.
16357 of 2010 be requisitioned to the next date. We're listing it on 12 September, the date already.
May I submit one thing, my lord?
Yes.
Your lordship has passed the interim order, nothing. But nobody should be allowed to carry out any illegal fishing there, including the petitioner, if that is not settled, because by virtue of this order, the petitioner will forcibly, anybody can go, nobody, because we have already evicted the encroachers. Now they will again reimburse and re-entry the...
All this becomes law and order issue then later. This is the problem. The minute we say nobody...
Because that is the... your lordship.
I don't know what the ground situation, you have to come back and tell us.
Yes, that is there. But only thing is that the status quo with regard to the Soiraj source will remain as it is.
No, the problem is if you're going for auction without evicting the encroachers.
That is page 101. That
So clearly you're going for auction. You will not be able to give possession because he's still in possession.
That is there. That is 101 page, your lordship. I will take only 1 minute.
Which year was that?
That is 2020.
So 2 years later. So many things happened 2 years later.
Within 2 years, they cannot re-enter.
Monty, I tell you why it's impractical, this kind of orders.
Yes.
In a village, there are so many fishermen.
And another thing, let me...
You can't find a whole village.
Your lordship may kindly have a glance over who is the petitioner. Petitioner is an individual, not the society.
Yes, he is the by mistake.
By mistake, what mistake? But kindly see, Dinabandhu Das, son of late Nityananda Das, who is the petitioner? Petitioner is not that society.
On behalf of the society.
Where he was stated so. The cause title does not indicate that he was the representative of that society.
The body of the petition, please read. I must have said.
No, your lordship may see what is the cause title. Cause title, the Dinabandhu Das himself is the petitioner. He is not representing you. What is his locus standi? The society is not before your lordship.
Anyway. All right.
No, that is a very major thing your lordship may kindly see.
You apply to vacate, then vacate. See, the problem is no counter is filed. Nothing is filed from your side. How are we supposed to proceed?
And if your lordship will, that affidavit part also, if your lordship will see that I am the petitioner, he is not saying that I am the representative of any society.
I have said in the cause title representing villagers of Koudi. Please read it.
There is no society. You are claiming that I am the representative of a society, registered society.
First of all,
where is that registered society?
Registered society will come, don't worry.
May I submit one thing, my lord?
Yes.
My lord, this is what my learned senior has submitted that belong to Banpur Tahsil. Actually, that plot is civil plot is not belong to Banpur Tahsil.
That is under Tangi Tahsil. He is saying that I know that it is on Tangi Tahsil. But it is Tangi Tahsil.
Banpur is in Puri district.
After division of Puri district, there are three the district has been divided, and Khorda and Puri. So Khorda and Puri, the village, disputed village, it belong to Khorda district. So petitioner village belong to Puri district, my lord.
Because it was all under Puri district.
My lord. Every document, each and every document submitted by the petitioner is before the division of the district. The division of 30 district divided into 30, number of 30, my lord. So prior to 91, all document may verify your lordship. All document before 94, not after the bifurcation of the district, my lord.
That is what he is saying, that it is all prior to the bifurcation of the district. What
let them file after bifurcation, who is there, who they have possession.
Yes. That it has been, my lord.
Anyway, you all file your documents. All right.
Your lordship is fixing to his
12th September, already fixed.
12th September.
Supplementary list item number 3.
My lord, I am before your lordship. For review of your lordship's order, dated 18/5/2022, I am before your lordship.
Okay.
The Lordship may kindly turn to page 12.
Right.
Page 12, last portion, result of revaluation. The candidate, while answering the above question, has only written that the trial of offence under Prevention of Corruption Act has to be dealt by following warrant procedure trial. The answer is very short and cryptic, for which he has been rightly awarded 0.5 marks. Now, your Lordship may kindly turn to page 41 of my writ petition. Got it, your Lordship, got it.
41 of the
Yes,
petition.
41. 41, last answer number 3. Section 5 of the PC Act lays down that the trial of an accused under the Act, the trial of the Act.
Trial court must
The trial court must follow the warrant procedures such as so and so, so and so. So, my lord, the answer, the revaluation answer is not in consonance with my answer. That is my, because I have stated specifically Section 5 of the PC Act deals with the offence. But while answering my evaluation, it is the candidate, while answering the above question, has only written that the trial of offence under the Prevention of Corruption Act has to be dealt by following the warrant procedure of trial. I have specifically written that Section 5 deals with so and so. If
No. That, of course, no. He's not disputing that. He's saying the whole answer is cryptic. It is.
No, my lord, my submission, that's what I have.
He's not saying it is a wrong answer, please. He's saying it's too cryptic.
My lord, your lordship, that must be read along with your lordship. May kindly turn to page 11. Page 11 of the page 11 annexed to the annex 2. Result of revaluation, last portion. The candidate has only written that Section 18 prescribes a bar and has given a citation which is wrong one. Hence, for writing that anticipatory bail provision is not applicable, he has to get 0.5 marks and another 0.5 marks for writing the section so and so. If that is so, here also I have said.
We can't do this dissection. This is why, see, ultimately we have to give it to an expert. We've given it to an expert.
But
beyond this, we can't do anything in a writ jurisdiction.
My lord, my submission because of this type of revaluation.
See, we don't evaluate papers day in and day out.
That is true.
There are people who are adept at these things. They do this evaluation. Beyond that, we don't go and sit in judgment.
But my submission from this type of case.
There'll be no end to this. This because two evaluators will have a different perspective.
My lord, the manner in which the valuation is being made, for which the lawyers are not being selected, this is the manner for which. My lord, because
see, the point is, you and I may have a certain perspective, but these are people looking at several answer sheets.
My lord,
see, if there are 10 candidates who've answered brilliantly these questions, it will be in relation to that performance only. Then I will say, if 10 persons can give me better answers, I can't give the same mark that I give those 10 people this person.
That is true. I don't say no, my lord.
Now, you are not seeing those other 10 or 20 or 30. You're only seeing this one answer. So you're thinking, oh, why not give more marks to this answer?
I am not in a position to file a answer sheet of another.
You cannot. That's why, you see, that's why the scope of judicial review is very narrow in this. See, if it is an objective, look at most cases, decided cases. If it is where the answer key is wrong, which means what? It's an OCR, whatever, that objective type. So yes or no, you can clearly say, okay, the answer is yes. He's given no, therefore no marks, or reverse. This is not that kind of a thing. You have to write 4 or 5 lines, then you will get a mark. Or for writing 5 lines or 10 lines, whether you should get 1 mark or half mark or 2 marks, we can't sit in judgment on that.
But one thing, your lordship, one must write for about 6 minutes. My lord, that is what he has given.
All right. Anyway, you've tried your hardest. Must compliment you on that.
Okay.
All right. No grounds made out for review. The review petition is dismissed. All right.
Supplementary list item number 4. Item number 4.
Shashi Bhushan Patnaik. You were sitting here just now, Mr. Monty. We'll pass it.
Supplementary list item number 5.
My lord, in item number 5, I have challenged, my lord, in VC.
Yeah.
My lord, I have challenged the manner of advertisements at certain points at Bhubaneswar in audio and video mode, which is in strict contravention of Orissa Outdoor Advertisement Coding Policy 2015, which was adopted on the direction of Honorable Supreme Court in MC Mehta versus Union of India.
This representation, have you actually delivered it?
Yes, my lord, I have sought the tracking report.
All right. The petitioner's representation shall be examined with the Principal Secretary, Commerce.
Lord, I am on behalf of the opposite party number 1. I have instruction to appear in the case. Let him serve a copy so that I can.
No, you just dispose of the representation, sir.
My lord.
Copy of the representation be examined by the Principal Secretary, Commerce and Transport Department. And after hearing the petitioner, an order be passed thereon, not later than 15 September 2022. The date of hearing the petitioner should be intimated to him at least 1 week in advance. The court clarifies it as expressed no view in the matter. You put down his appearance. A copy of this order be communicated to the Principal Secretary by counsel for the respondent forth.
Niranjan Punda 1.
Respondent number 1 forth. All right.
Supplementary list item number 6.
May I please go? My lord, item number 6 is a public interest litigation, which is about the inaction of opposition party for non-completion of road work since 2018. My lord. The annexure 4 is pending, my lord, which has been 3rd March 2022.
Annexure 4.
4, my lord.
NHAI.
Yes, your lord.
But this has gone to Delhi. What is the point?
Sorry, my lord.
I don't know. It's better to call the counsel for NHAI here. You serve a copy on Mr. Amitav Das.
Yes, well.
Mr. Das, you've got a copy of the petition.
We have already served a copy, my lord. We have already served a copy.
He's appearing.
I have the receipt.
He's appearing before you. Just see that.
He might have issued to Union of India.
Please serve it on Mr. Amitav Das. He's there on the screen. You have to find out and serve it. Let him take instructions. So, a copy of the petition be served on Mr. Amitav Das, learned counsel appearing for the NHAI, to enable him to seek instructions. List on 6 September.
Supplementary list item number 7.
Item 7. My Lordship's order dated 13/7. Lordship directed notice to OP number 5. The OP number 5 has already entered appearance to caveat. I have already served him. Also copy on 13/7 on the same day.
All right. Why has it come today?
That notice has not been issued. That's why it is.
Requisites not filed. That is
all right. Counsel for the petitioner points out that OP number 5 has already entered appearance, so there's no need to serve him.
I've already served copy.
All right. Copy is already been served on counsel for OP number 5. Notice therefore need not be. No, requisites need not be filed for OP number 5. All right. List on 14/9. The date already fixed.
Right. List.
Supplementary list item number 8.
Wait, please, your lordship. My lord, the petitioners herein are challenging the decision of the opposite parties in shifting the location of the Kishoreganj primary school from its present location to the campus of RD High School in the Kishoreganj, my lord. And the facts of the case are as such that
representation must be there.
My lord, after the representation, they have passed a report, my lord. That is at Annex of 4. They have, and pursuant to their report, they have already demolished the school, some of the school boundaries and also the classrooms, my lord. My lord, the facts of the case are due to the expansion and upgradation of the NH 55. The road had to be widened, and from a 2-lane road to it was to be constructed a 4-lane road. Pursuant to that, land was acquired, and the present this primary school being a land adjacent to the national highway, that was acquired. After knowing that a resolution was passed in the Mo School Abhiyan committee of this primary school, that since new classrooms have to be constructed, as per this resolution, they proposed to the Tahsildar that the land behind the present location, the land behind the school, that may be recorded in the name of the primary school, and the new construction be made on that location. But after that, the Tahsildar made a field verification, and the report is at Annex of 4, my lord, page number 33. There, the Tahsildar has submitted the report that they have given the reasons why they are shifting the school to the RD High School, Kisorganj, my lord. My ground for challenging this decision is that the safety of the children is the primary consideration, my lord. All the children are aged between 5 to 10 years, because primary school 1 to 5 class, my lord. All these children have to cross a national highway, that is a 4-lane national highway. And in reply, the report they have only mentioned that there will be a flyover and we'll construct an underpass. But how can they expect the children aged between 5 to 10 years to cross that highway? They will be exposing the children to the dangers of vehicles, my lord. After that, my lord, another ground is the question of distance, my lord. In regards to distance, my lord, from the present location to the neighborhood from where this Nunukapasi village, from where the children are coming to the school, the distance is 940 meters, my lord. If this school is relocated,
40 meters is less than a kilometer.
My lord, if the school is relocated, the distance is 1,670 meters. Means
1.5 kilometers.
More than 1 kilometer, my lord. And that is in violation of the Rule 6 of the Orissa Right to Education rules, my lord. It says that as far as possible, the elementary school should be within the limit of 1 kilometer, my lord. And if necessary, if there are further dangers, that limit can also be reduced, my lord.
May kindly see page 83. There's a representation pending.
I know, but the question is, he says they're already demolishing.
29/11/2021, they have demolished the boundary walls. And also,
boundary walls is one thing. The school is still functioning.
Some classrooms have also been, and the children are continuing their schooling in those dilapidated buildings, my lord. And they are in the report, they have mentioned that there is space in the RD High School. In the RD High School, they have demolished a hostel. There was a hostel. Now, I have also annexed the SMDC meeting, School Management Development Committee. Their report is at page number 90. Even they have objected that due to demolition of this hostel building, now hostelers have no facility of hostel facility. Also, they have no facility for the smart classrooms and also other facilities. So now, SMC of the objected, SMDC of the school to which campus it will be, they have also objected. And the students have to cross a 4-lane road, and the only reply is that
now a class is going on or not in your presence?
Class are going on.
How many children are there?
120 children, my lord.
This is a serious problem, I see. Better take instructions. You see, notice. He accepts notice for
3, 4, and 5.
You've made everybody headmaster, and what is this president? Everybody. Why do you need to make so many opposite parties?
Well, they're all are there, the NHI, and they all are stakeholders in this piece, man.
1 to 5.
Well, one is school and mass education. They have their own.
Who's that?
Mr. Parida.
So you ask Mr. Parida to take notice.
Well, it's 3, 4, and 5 minutes again. Collector, sub-collector, and the Tahsil.
3, 4, and 5. Mr. Parida is requested to accept notice on behalf of this. Elementary education is another department.
That is under
under school and mass education. School and mass. So
on
Mr.
behalf
Parida
of opposite parties 1 and 2. You better serve a copy on Mr. A.B. Parida.
My lord.
S. Parida.
S. Parida. Sorry. Mr. S. Parida. Counsel of the petitioners states that at present 121 children.
120, my lord.
120 children are studying at the Kisorganj Primary School.
My lord.
And will be put to great inconvenience 126 you have said in your petition, you are saying 120 here. Great inconvenience if the school is shifted to the premises of the RD High School. What does RD stand for? Kishorganj, as is being proposed by the SMME department. So it is pointed out that they would have to cross the National Highway 55, which will pose a great risk to the life and safety of the children. The status quo be maintained till the next date. Based on 12th September.
Obliged, madam.
Supplementary list item number 9. Item 9.
My lord, item 9, my lord, I'm in some personal difficulties, my lord. I pray, my lord, kindly take it up.
There is a representation and representation is to be
My
disposed
lord,
of.
that is on annexure number 1. Earlier
Annexure 1. Collector will, or ADM revenue of Kendujhar, he will dispose of his representation first. That is the only grievance, that my representation is not being taken care of.
My lord.
Petitioner's representation. Bracket annexure 1 be considered by the collector.
Yes, collector.
And after hearing the petitioner and getting inputs from opposite party number 4, a reasoned order shall be passed thereon not later than 10th October 2022. And the copy of the order be made available to the petitioners within a week thereafter. The court clarifies it has not expressed any view on the matter. Petition is disposed.
Supplementary list item number 10.
My lord, some defects are there, my lord. I may be permitted only. Please give 1 week time, my lord, to comply
Counsel, the petitioner states defects will be removed within a week. List thereafter.
Supplementary list item number 11.
May I please, Lordships?
Yes.
Lordships, this is the matter regarding the refund of that excess amount of advance tax paid. And as per your Lordship's direction, the assessing authority also disposed of the representation. But kindly have a glance at page 20, the order, where he has also stated his concern about the assessee and stated at page 20, paragraph 4. The bit B, if there is any genuine defect in 143(1), the AO can do rectification under section 154 of the Act and release the refund. So he has the power of refund, but under 154. And next page, he has also stated that there is no provision under Income Tax Act which empowers the AO to release the refund before filing of income tax return by the assessees for concerned assessment year. In this matter, also he has he has stated that therefore, though we are concerned equally with the assessee about assessee's difficulty in this in his day-to-day business activity, however, as per law, assessee has to wait till 1 year. My only grievance before Lordship, that my respectful submission before Lordship, that this is not freeing from assessment. Only it is a rectification. So he has admitted that through rectification, if my return is rectified, then he will be able to release the refund. So my humble submission before Lordship, that because his livelihood is at stake, so and it is a
What's
very
the amount involved?
In place of 7.5 lakhs, he has deposited 75 lakhs.
Oh.
So 67.5 lakhs he has to be refunded. And page 13 is my representation grievance petition before the officer. And now
there is no such provision under the IT Act to give the refund. Only after the assessment will.
No, the court will direct then.
That is.
You see, from the petitioner's perspective, the having to wait for 1 year to get a refund of rupees 67.5 lakhs, which is wrongly paid, and which is admittedly to be refunded to him, seems unfair. Stop. A reply has been given to the petitioner by the ACIT Circle 1 Bhubaneswar that as per law, he has to wait till the filing of the return and only then he'll get back his refund. Full stop. It is pointed out that the rectification application has already been filed, and under section 154 of the Act, the assessing officer can carry out the rectification, and once that is carried out, the refund can be made without having to wait for the assessment to be complete. Paragraph. In that view, the matter, it is directed that you've already filed the rectification.
I will file.
If the petitioner files a rectification application within 2 weeks from today,
Within 1 week, Your Lordship. Within 1 week, I will file.
within 1 week, the AO will process the said rectification application and pass appropriate orders thereon within a further period of 2 weeks thereafter. Full stop. The refund found already due to the petitioner will then be made to the petitioner within a period of 2 weeks thereafter. The petition is accordingly disposed of.
Supplementary list item number 12.
Your Lordship, page 21, Your Lordship may kindly turn to page 21.
Covered.
Your Lordship.
All right.
Your Lordship, also item number 22, 23, 24. Same state revision, that is 39,
The order
43.
passed to this court on 1st December
In all
2021
these cases,
STRE 64
assessment,
of 2016, bracket Keshav Automobiles, the state of Orissa, which has been upheld by the Supreme Court by its order dated 13 July 2022 in SLP Civil 9912 2022.
22, 23, 24.
The present petition is dismissed. Same order is in
22, 23, 24.
22, 23, 24. All right.
Supplementary list item number 13.
As item 13, pursuant to the last order, we have filed an additional affidavit dated 20th of July 2022. My lords, may kindly see para 3.
So let me start, sir. Lad, this is an application of PAL for the purpose of lad declaring Salehpur as a lad NAC under Article 143 Q2 and Section 4 of the Orissa Municipal Act 1950, Malad. On the last occasion, the learned additional government appearing for Malad, he has said that they had earlier filed a counter, but in the meanwhile, about 4 years have elapsed. What steps have been taken by the government thereafter, Malad, that he wanted to point out, Malad. But now, in view of the counter that has been filed, Malad, Lordship will just see at paragraph, Malad, the counter that is in.
What is this all within the government? You're endorsing it to some department. It does not come back. You should be able to tell us for both departments.
Lordship, just see paragraph, page 4, para 9. Page 4, para 9 of the counter affidavit, Malad. In reply to the amendments made in para 5B of the petition, it is submitted that the collector Cuttack via the letter number Swens of 9th of February 2016 once again submitted the proposal to the Director Municipal Administration, Housing and Urban Development Department for constitution of the new NAC at Salehpur, as received from the Tahsildar Salehpur of Cuttack District in Form B, along with the sketch map as per the provisions laid in Section 4, subsection 2 of the Orissa Municipal Act. Once again, the collector Cuttack via the letter of 206 dated 29 June 2018 confirmed that necessary information has been submitted to the Director Municipal Corporation, ex officio additional secretary to government, with reference to government letter number so and so. Further, once again, the collector via the letter of 7th January 2022 submitted the information on revenue generation and resolution of Chandradepur, Balisai, Barigol GP for constitution of the new NAC at Salehpur with reference to the letter of 6th December 2021. And they only say, my lad, in the Lordship, thereafter, Lordship, kindly see the additional affidavit 5, my lad, the opposite parties 1 and 2. In the additional affidavit, my lad, they are saying.
Gone to the water department.
No, it's the Panchayati Raj department. Their view is required.
No, but you can't get stuck like this. It's all of the departments are, as far as we are concerned, state of Orissa is one entity. So what is the point in telling us it's from this department to that department? You have to give an answer.
Give me some.
No. We'll ask the secretary to remain present here. Secretary Panchayat Raj Department.
No, that's the Housing and Urban Development.
Filed on 20 July 2022. It is stated that the file has been endorsed to the Panchayati Raj and Drinking Water Department on 20th April 2022 and has not yet been returned to the Housing and Urban Development Department. Stop.
May I submit? Let's may grant 2 weeks time. In the meantime, I will get the instruction whether it has been approved by the.
All right.
But only one thing what falls from my Lord Chief Justice Palad. Exactly in the similar direction, there is a judgment of the Gujarat High Court, Malad. Malad, it is, I have given a copy to your Lordship earlier, Malad. I'll just take a Lordship one para only. Exactly identical way Gujarat High Court has disposed of, Malad. The language is, Malad, in paragraph 11. I have given compilation of judgments. If it is not there, I am passing on to my copy to Lordship Palad. I have highlighted those portions.
So let them take a decision. We've seen this. Let them take a decision.
Yes.
All right. Mr. Mudli states that 2 weeks' time may be granted to seek instructions on the current status at his request list on 22nd August. No, 1 minute. Sixth September.
Now which date?
6th September.
Blessed.
Supplementary list item number 14.
Not here, it's a public interest litigation in fact. The petitioner before your lordship is seeking a direction for removal of the installation of mobile towers, which is near a school and a hostel. My lord, while going through that documents from the counter affidavit, I find that they are producing certain letters and other documents wherein they have got permissions. Well, those have not been put. I only pray your lordship may allow me withdrawal of the petition to file a better application with all other parties.
All right. Counsel of the petitioner seeks leave to withdraw the present petition with liberty to file a better petition with full particulars. Disposed of his withdrawal with liberty is prayed for.
My lord, in this matter, I am appearing for the Union of India, my lord.
All right.
I am for the BSNL, my lord.
All right.
I filed a counter also in this case.
All right.
We have already filed our counter, my lord, in this case.
You have not heard the matter, sir. You have not heard the order.
Supplementary list item number 15.
My lord, even though I have filed the challenge the input order of rejection passed by the government annexure 7, my lord, the government has not filed the counter. The law department has not filed the counter, and the counter as it indicates the opposite 4 and 5, but copy was not solved.
My lord, I am appearing on behalf of for opposite partner 5, my lord.
Counter 4 and 5 have filed counters, sir.
4 I have given.
4 is filed, 5 is also filed.
They are the proper, the main contesting, my lord, the OP1, the order of rejection passed by, they have not filed the counter. OP1 has rejected the order.
They'll adopt, I think.
Yes, my lord, item 16, my lord.
No.
15.
Sorry, sir. In fact, whether the judgment rendered in the case of Anandas will be applicable to the petitioner, or that is the point to be decided. In fact, he has joined after the new pension rules came into force.
Okay.
That is NPS scheme. But since the process was initiated prior to the amendment of the rules,
So my lords have held in Anand.
The same benefit will be applicable. Do you have the order?
I have given to judgment of your lordship, Delhi High Court, and it was confirmed.
Sir, 1 minute.
My lord.
We have passed orders here in this court. Do you have copies of those orders?
The lords may give a short date. I will.
No. There is an order.
Call it tomorrow so that I can produce those.
All right. List tomorrow.
Supplementary list item number 16.
Yes, Mr. Padi.
Yes, my lord. In that case, I sought for instruction, but I didn't have. But there is a main contesting is the BCI, Bar Council of India.
No, the main contesting is the State Bar Council. I am for the BCI.
Your Lordship, I'm on behalf of Mr. Anurag Pati. On behalf of Mr. Anurag Pati, we have not received the counters, Your Lordship.
No, I have not filed any counter, my lord.
We have not filed any counter. In fact, my lord, their entire grievance. My lord, I am for the Bar Council of India.
No, I know that. Who's for the State Bar Council?
I am for the State Bar Council, my lord.
So
I have not filed any counter, my lord.
You don't want to, or you want to?
No, I will file counter, but I'll take your lordship to say page 52, my lord, of the petition, my lord.
Yeah. Yes.
They are challenging, my lord, serial number 2 for that total enrollment fees is 42,100, my lord.
Yes.
Yes, my lord. Your lordship will see welfare scheme 10,000 death benefit and 3,600. It comes to 23,600, my lord.
Sir, you can't do this Robin Hood thing. You can't ask every small young graduate to pay this huge amount for you to fund your welfare scheme. See, on the other hand, your welfare stamp has gone up to so much. What is the audit of the already collected amount? How much have you spent from that?
That I will.
Unless you file a counter, we don't know. You go on collecting. Ultimately, litigants are paying enrollment fee. The lawyers are paying. The young law graduates are paying. Litigant is paying 100 rupees now.
We are paying, my lord, death benefit, my lord, 1 lakh rupees.
Sir, there has to be a limit to how much you will charge young enrolled young lawyers.
Young lawyers, my lord. That. Because
and look at the disparity. A law graduate in Delhi has to pay 15,000. A law graduate in Orissa has to pay 42,000.
They are charging building fees, library fees, which we are not charging.
Sir, whatever they charge, it never comes to 42,000.
Yes.
It seems exorbitant by any standard.
No, because they have no welfare scheme, my lord. We have got.
Sir, who's to subsidize? Who's to fund this welfare scheme? Young law graduates. You have to apply your mind that way.
Yes, my lord.
What is the answer to a 24-year-old to say, no, when you become 65 years old, you are going to get, it's not some LIC policy, sir.
No, not that way, my lord.
It has to be rational. Ultimately the burden, you are not yourself doing any charity, you are putting the burden on others, right?
Yes.
You shouldn't put a disproportionate burden on such young people. You will discourage them from joining the bar. It becomes counterproductive.
6,000, my lord, other bar, because of the gazette notification issued by Bar Council of India, my lord. But your lordship knows, on the recommendation of the National Law Commission, Parliament issues, my lord, direction. In 61, it was 250, my lord. In 1993, it was 750.
Sir, if you want to file a counter, you file. Yes. If you want to argue right now, you argue.
No, my lord, I will file a counter, my lord.
Mr. Amitav Das, appearing for the Bar Council of Orissa, seeks and is granted 4 weeks' time as the last opportunity to file a reply.
Yes.
Rejoin to be filed before the next date. 11th October.
Must apply your
Supplementary list item number 17.
My lord, on behalf of Mr. DK, sir, let it come next week, my lord.
Plus, the collector's order is quite clear.
Nice, 70.
Consider petitioner stated to be in some personal difficulty. 21st November.
Supplementary list item number 18.
May it please, your lordships. Well, as on the last
You
day,
have to amend what happened.
I have filed that application is there, my lords. That rejection of my objection, I have filed that order, my lords, on last occasion by way of an affidavit. If your lordship will kindly remember. And now I have also, it relates to that whether an opportunity of hearing is necessary.
All right. You say the IA number 10386 of 2022 for the reason stated therein the application is allowed. The consolidated petition be filed before the next.
I have already made it ready.
All right. The consolidated petition is taken on record. Copy served on?
Yes, yes.
Copy note, sir.
Copy our Kali Ratre diya hai. I am serving the copy now.
One.
Yes, yes, I am.
He's filing so many cases.
I am benefiting you. You should do good. He says it is wrong.
He's filed some other cases. He filed consolidated petition at 9:10. I especially mentioned a time.
May I pray there is an interim
interim order to continue and list on when are the other matters coming up?
Well, on 10th of November.
10th November. All right.
But further proceeding for AY 1516 matters.
Yeah, all further proceedings pursuant to AY for AY 1516 shall remain state. All right.
Matters. Much obliged.
Supplementary list item number 19.
So, these are three matters.
Yes, yes.
Your Lordship will find that STRB number 75 of 2011.
Yes.
Where the learned tribunal, without following an order of the tribunal which gave relief, went in to decide the matter relying on a judgment of the Supreme Court in the case of Rajasthan roller flour mills, where it decided that wheat and wheat products are different.
Right.
And then I am challenging because of that. That order came for consideration before another bench. I will take your lordship to that. But the question of law, which is framed in two of the cases, is this. This was framed on 5/5/2005. Whether the facts and circumstances of the case and in the position of law decided in the matter, the learned authority below are correct in imposing tax at the residual entry of at 12% on Robinson barley, purity barley, pearl barley as having higher utility than the commodity consumed. Thus, the requirement is to give an interpretation to the word barley, which is a cereal and which has been notified under a statute under Article 286(3). And then, my lords, I'll take your lordship. I have given in the note that this Article 286(3), when you amend it, before amendment, in my notes I have said, in my notes for virtual hearing notes, page 21, I have made the comparison of pre-amendment and post-amendment. The pre-amendment said, no law made by the legislature of a state imposing or authorizing the imposition of a tax on the sale or purchase of any such goods as have been declared by the Parliament by law to be essential for the life of the community shall have the effect unless it has been reserved for the consideration of the president and has received his asset. After amendment, Your Lordship, any law of a state, pre-amendment of no law of a state and any law of a state shall in so far as it imposes or authorizes the imposition of a tax on sale or purchase of goods declared by Parliament by law to be of special importance in interstate trade or commerce. The president's assent or reserve for president assent is taken away, be subject to such restrictions and conditions in regard to the system of levy, rate, and other incidents of tax as Parliament may by law specify. Now, so far as the first pre-amended, the Parliament specified by a law called essential, that law came in 1952, that the Essential Goods Declaration and Regulation of Tax on Sale and Purchase Act 1952, there they defined cereals, which I have quoted in page 22. Cereals and pulses, together they have said, in all forms, includes bread and flour, including atta, maida, suji, bran, except when any such article is sold in a sealed container. So therefore, when we speak of an essential commodity, the Parliament having made this provision, which means that it just exactly what Rajasthan case says, that it does not include, but the Act had included. And subsequently, when it comes to another Act, this was repealed by the Central Sales Tax Act. And for the first part, these cereals and pulses did not come into the existence. And therefore, they were not declared commodity for some time. But little after, they were goods to be of special importance in interstate trade and commerce. Inserts in Serial 1, cereals, that is to say, because Your Lordship is aware that that is to say is in that famous case, Parilal Malhotra, speaking of steel and what are the product of steel. That is to say has been, and in Rajasthan also they have pointed out, in my footnote I have given, but that is to say, then it enumerated subheads of clause 1, cereal, that is say in inverse of it, and special importance, barley, simpliciter barley. Now, barley has to be on several forms, because normally, if I say paddy, one cannot eat the paddy. Paddy has to be converted into rice. But fortunately or unfortunately, paddy and rice have both been sold as essential commodity in 2 items. But in order to reduce the tax rate, section 15B, CA, C, CA, and D have been modified. The statute itself gives concession wherever they are made, sold for a second, or they are converted. And the 15D, it says that the food grains, dehusked and husked, are the same thing. Now we come to the judgment. Your Lordship is aware of the famous judgment, Tungabhadra. Tungabhadra is a judgment which said, I've given summary of it.
Mr. Mohanty, just answer one question. If I go into the market and I ask for barley, I will certainly not be given Robinson barley.
You will be on, Your Lordship will be given only Robinson barley.
No. Robinson barley is identified product marketed by you under a separate heading, and you subject barley to certain processes to produce Robinson barley. That's very clear from your note itself.
That issue has
already been decided.
This issue has already been decided in one judgment. I have submitted.
No, 1 minute. Just come to internal page 8 bottom, sir. About Robinson Barley. What you say about Robinson Barley?
Well,
Your own note, page 8 bottom.
Well,
Let's read that carefully.
well. I'll take 1 minute. Sorry, I'll take 1 minute. Yes, bro.
Yes, if you read that, Robinson Barley and Purity Barley. Page 8 bottom, sir. Internal page 8 bottom.
I'm just skipping over this. I'm not that packet that comes in, not in the notes for virtual hearing.
So you've given us a note synopsis.
Yes.
The synopsis of running to, I think, 26 pages.
Yes.
4th July 2022. Filed done.
Apologies, Lord, but what your lordship is saying, I am also agreeing on it. But there has been a judgment, firstly a judgment of your lordship's court, which says, follows the judgment of Rajasthan and confirms the order against you. If your lordship follows that, then your lordship has to dismiss by this.
All right.
But I am praying to your lordship that in view of several factors, this judgment of Rajasthan is not correct, because it says that it should be interpreted literally and follows Ishwari Khaitan. Ishwari Khaitan is a different interpretation under entries, which are considered under the Hindu Rampur case to be a denuded power. Now, when a denuded power comes up, then comes the question, because it restricts, and therefore Ishwari Khaitan says that it should be strictly followed. But that is not parallel for which it should be strictly followed. Then there are, I have said, my lords.
Yes.
You'll be permitted to read four reasons why Rajasthan should not be followed.
All right.
And Rajasthan has been, Justice Jivan Reddy sitting in a division bench along with Justice Hansaria in the case of Telangana has explained in detail I have mentioned about Satyanarayan Bhandar, which is serial number 26 of the compilation I have filed, which is against me. But I am saying that Rajasthan is entirely wrong when it interpreted the word barley to be strictly interpreted as Ishari Khaitan, which is also wrong. Rajasthan, for a difference of opinion, came to it, and Rajasthan examined the scheme of the constitution that empowers the state to levy tax on sale of goods as vested in the state entry by 44 list 2. 54 list 2 is a power which is a denuded power. And how the denuded power will be read has been put into academically by many, and particularly the Shirvai in the 4th edition. The prohibition with respect to interstate sale and sale effected in the course of import remains, though framed differently. However, so far as the declared goods are concerned, the absolute prohibition has been given way to restrictions and conditions as may be imposed by Parliament by law. And the arguments that were advanced before the Rajasthan bench,
yes,
which I have put it in my notes on page 4.
Yes.
Wheat is a staple food, because this is the argument made. Wheat is a staple food of majority of population in this country, is not consumed as such to be grounded, milled into flour for its consumption. For certain purposes, wheat is milled into maida or suji, as the case may be. Flour, maida, or suji are not commodities different from wheat. Even after being milled, they continue to be wheat as merely a different form of wheat. The idea behind the 1976 amendment, which introduced clause 14, section 14(1), is to save cereals, that is the wheat, from excessive or multiple taxation by the states, and to make the same available to consumers without being unnecessarily loaded by the tax burden. I have already stated before your Lordship that section 15, B, C, A, and D are provisions in the law itself when there is a higher tax. And therefore, they say in what circumstances those taxes will be refunded or will be considered the same goods. They have said this. So therefore, the object is to take these taxes must be reduced down. That is what was argued. And said that common parlance, wheat, flour are not different from, are not understood to be different. Taxing the wheat as well as the flour, maida, suji, treating them as different commodities, would defeat the very purpose and object for achieving which clause 1 was introduced in section 14. This question or this issue was not answered in the Rajasthan case, but this was answered in the Telangana case, which came subsequently there too, and where Justice Reddy was a member. The government argued the next page.
Yes.
If wheat includes flour, derived from it, then paddy should also include rice, because just as wheat is obtained by milling wheat, rice is obtained by milling paddy. Yet rice is mentioned as a separate commodity in clause 1 and 2. I have already shown to your lordship that when rice is made out of paddy and are sold in course of interstate trade or commerce, no tax, the tax is refunded to person who has paid. When rice is made and from paddy and sold in course of export, no tax is either on paddy or rice. And like this, the state itself, the legislature itself reduces. Now, this position has been explained. A particular paragraph, which is page 2455, para 2 to 22.239, seed-wise 4th edition, 3rd volume. He says, the object of the amended Article 286(3) was not to destroy all charging sections in the Sales Tax Act of the state which were discrepant with Section 15, Central Sales Act, but to modify them in accordance therewith. The state law is declared to be subject to restrictions and conditions contained in the law made by the Parliament, and the rate in the state would be pro tanto stand modified. The assent only makes, because the assent is in the first part, only makes the, if the existing law, then section 3, Article 375 will continue that law with modification. Now,
Mr. Monty, we'll just finish the rest of the board and continue. Just it will take us 15 minutes. We'll just finish the rest of the board and continue. All right. All right.
Supplementary list item number 20.
That's item 20 on behalf of Mr. Katki. I'm seeking a day's adjournment. He's suddenly taken unwell.
Who?
My lords may keep it to Mr. Katkia. He was doing this matter.
All right.
My lords may keep it tomorrow, my lords.
All right. Can't be tomorrow, sir. Tomorrow's Thursday.
Can it be day after tomorrow? I have got some difficulty. Any other day?
This is the one that has come back from the Supreme Court, right?
Yes, yes, yes.
Mr. Katkia, learned counsel for the state is stated in some personal difficulty to pay. Let's turn. Can't be in September, it's all chock-a-block all. October 17th.
Great. Supplementary list item 21.
Your Lordship, item number 21 may be dismissed so far as the paltry amount. Why, Your Lordship? In the assessment, the amount is 1,77,000. But here, Your Lordship, on each point, the tribunal has confirmed. Only the ground here is that 6,63,475 is the enhancement. That has been reduced to 38,000. So in essence, if 4% tax will be calculated on the difference, then it will be 25,000.
Or you say,
so let the question of law be open.
Insubstantial tax of effect. The court is not inclined to interfere. However, the question of law, let for consideration.
Great. Supplementary list item number 25.
But the item 25, this is relating to that PIL, my lords. In the Neempur rehabilitation site for developing that area, my lords. The last date, my lords, are directed on 13th,
correct.
On 13th December 2021, my lord had taken a video.
Who's appearing for them? Who's appearing for them?
My lords, Mr. Suhail is appearing for petitioner Afraz Suhail.
There he is. You were to show us from the ground now. What is the development?
It was directed to be listed on 17th January, but I think that was not listed thereafter.
What's the ground situation now?
Your Lordship, I have some photographs also. It's similarly as it was earlier also. And even the rainy season, the situation is getting more bad.
Let them serve a copy because as far as the instruction, my lord,
The petitioner has brought photographs to the court to show that the situation is as bad as it was earlier in the colony in question. A copy of the photographs be served on counsel for the CMC.
CMC.
Today itself. The court would like to see the ground situation in real time on the next date of hearing. List at 2 p.m. on. You ask somebody to be in the colony.
My lords. My lords, as per the instruction on the last date, as we appraised your lordships, tender was floated and that has been finalized and work is under progress. The road work will be completed within, my lords, 2 months around, and the toilet works regarding the construction of the septic toilets and all that will be completed around 1 month, my lords, within 1 month. And rest of the street lights and water supply that already have been provided, and maintenance is going on every day, my lords.
So we're going to list it on 22nd September at 2 p.m.
My lords, my lords.
All right. All right. Sufficient time for you to set right.
Yes, ma'am.
Supplementary list passed over matter item number 4.
May I please, my lord? My lord, I want to withdraw this petition with the liberty to approach the NGT.
All right. Counsel the petition seeks leave to withdraw the present petition with liberty to approach the NGT in accordance with law.
Obliged.
Disposed of is withdrawn with liberty is grateful. All right. Yes, Mr. Monty, you can continue.
I was pointing out the difference
Yes.
between the Rajasthan case and Ishwari Khaitan's case.
Right.
Ishwari Khaitan's case was considering a declaration made by the central government.
Right.
Which was under the IDRA Act.
Right.
And in that case, the Act prescribed the extent of control and specified it. As the declaration trenches upon the state legislative power, it has to be construed strictly. What is the remnant of the state legislative power is decided not by Hingir Rampur, which says that it is a denuded power.
Right.
And they have explained the denuded power. And denuded power has been explained almost by about 300 more cases of this on the Supreme Court. But in Rajasthan, the Honorable Justice Jivan Reddy relies on 3 judgments, which is called Ganesh Reddy, Baburam, and Raghuram. All these 3 judgments have got illustrations in their explanation that wheat and wheat power. And therefore, they rely on this. Unfortunately, because Ganesh decides in a manner, and Baburam follows it, and Raghuram follows it. And then Justice Jivan Reddy followed it in Rajasthan. Now, this particular Ganesh Reddy went to the Supreme Court in a case from Orissa. That's a case which went Titagarh papers. I have some memories about that case because I have seen that case before the Honorable High Court.
Okay.
They lost them here at the Supreme Court. The question was whether timber and shorn timber are the same or not.
Right.
And ultimately it was held that timber and shorn timber are the same and therefore they can't be taxed twice. Now in that case, while arguing before the Honorable High Court, I had given notes, which fortunately notes I was able to get it.
Oh, I see.
This is a concept comes from the 1st century.
Okay.
And then jurists, philosophers have made mention about it. If your Lordship, I have given that, if your Lordship looks the reasons on which same goods and different goods are considered, they will be very much parallel in Tungabhadra's case. I'll bring it. But so far as the Odisha Supreme Court is concerned about Ganesh trading. They said that after careful reading of Ganesh trading, found 4 reasons to doubt it. First, no evidence before the court to show how paddy and rice were understood in commercial circles. 2, what those words meant in commercial trade or trade parallels. 3, by only referring to various authorities dealing not with rice or paddy, but with other goods. And 4, the meaning in ordinary parallels, the words paddy and rice, in order to ascertain the meaning of those words in the sense stated by it. And as Rajasthan did not take it, so they said Ganesh is not correctly referred to. Now the question is, if these 4 questions would be put in to get the real answer. My submission is neither the assessing officer nor the tribunal has put these questions so that they can get a correct answer. They just go by saying this. But in the meantime, there is another judgment which has come. I may be permitted to place your lordship. Tungabhadra, a few lines. Neither mere absence, because Tungabhadra, the oil seeds were expelled and groundnut oil came. From that, they made another oil, hydrogenated oil, which is called Vanashwati. And there, the High Court said that is the observation of other matters, and the intermolecular changes necessarily affect the identity of a substance in ordinarily understood, which Tungabhadra said no. Neither absorption nor intermolecular change will alter the identity. Because they gave an example that even if you have a bad oil, but still it is a groundnut oil. And then they said oxidative changes, and particularly the conversion into aldehys, as believed to be responsible for the sharp, unpleasant odor and the characteristic state of rancid oil, if nothing were done to retard the process of rancidity, may increase it to such an extent as to render it unfit for human consumption. Change here is both additive and intermolecular, but yet it could hardly be said that rancid groundnut oil is not groundnut oil. And then the question is, how do you read these words? I refer to, I already said about Rampur Hinge, then Jagannath Bakshi, AIR 1962-1563, cardinal rule of interpreting the words used by a constitution in conferring legislative power was that they must receive the most liberal construction. And if they are words of wide amplitude, the construction must accord with it. If a general word was used, it must be construed as to extend to all ancillary and subsidiary matters that can reasonably be included in it. Because I'm submitting to your lordship, I'll be submitting, that if barley is taken with a primary material and its powder, grounded powder, is subsidiary matter, they must reasonably are included in barley. Then the Calcutta Gas Company had said about entry 97 district, when having certain conflicts, has decided that the state list should be given a broad, plentiful interpretation and should not be interpreted in favor of the center by resorting to a residuary power. The residuary power cannot be interpreted so widely that it curves down the power of the state legislature, thereby affecting and jeopardizing the federal principle. So this federal principle was ignored in Rajasthan's case. For any subject, residuary power should be last option. It should be only held when the categories in the 3 lists are exhausted. Because I have got here, before your lordship, entry 13 and entry 16 and entry 126. entry 13 and 16 are specific entries of barley. Then they say what it excludes and what it includes. 4% tax at purchase point. The residual is that all other goods 12%. Now, if you go to residual goods, the law is settled that you must first say that the other two are not arising. Then, Milord, I've already said about Telangana steel and Justice Hansaria, we had a lot to do with him because he was with us for a long time. And his way of saying that law has some bright patches as well as some gray area. Some areas remain gray despite best efforts to illuminate them in enlightening judgments. As they get engulfed in the darkness or become part of the true light zone, either because of typical climate condition changes in conceptual formats. In the present case, the court are concerned with that's then explained that when a new commercial commodity comes into it, that is the case of iron rod and wire, where iron wares were drawn from the iron wares were drawn from the iron rod. When a new commercial commodity comes into existence, following processing or manufacturing undergone by the parent object, which is most cases serves as raw material for the end product. Similarly, we consider hydrogenated oil continues to be groundnut oil, notwithstanding the processing, which is merely for the purpose of rendering the oil more stable. Several minutes I would take to your lordship to Rajasthan was the Telangana, and ultimately the loss. Telangana relied on the judgment of Guwahati High Court modern scandal.
Right.
And there they say, because they refused to say that Honorable Court did not propose either to catalogue them, that means whatever the principles have been said, or even examine some of them to find out as to why. On one case, it was held as a new commodity, and the other in existence in another different view was taken. It would be enough if you note some leading decisions, such as from Tungabhadra to Raghura. Then the most important is an edible goods or not. The difference has to be made whether it's edible or not. And to what tests should be applied in both these types of articles, where then stated 5 guidelines. From the above decision involving edible articles, from the criteria found are whether the entire entry article is a genus of which the test article is specific, whether the essential characteristic of the entry article is still to be found in the new article, whether there has been addition of external agents, thereby making it different, and whether there has been a process of transformation of such a nature and extent as to have resulted in the production of a new article as commodity understood in the market where it is dealt. So long as it does not result in a new article, in nature, duration, and transformation of the original commodity should not be material. Then I'll take your lordship. There is another direct judgment. In my notes, page 26, para 46, there is a judgment of the Supreme Court.
Yes.
In the case of National Cereal Product, 2005, 3 SCC 366, para 11 and 12, I quoted them. Counsel for the appellant then referred to various other dictionaries to contend the malt is neither cereal nor food grain.
Yes.
Powdered, here the case is according to revenue, powdered barley is neither a cereal nor a food grain. The grain, according to the appellant, is a seed which is yet to be germinated. The court considered the various dictionaries meaning referred to by the appellant. In none of them has the word grain been limited to an ungerminated seed. Notice, here also cereal has not been limited to a unpowdered seed. On the contrary, malt has been described as food grain. The notification by which the rate of tax has been fixed in the respect of food grains makes it clear that the definition of food grain notification is wider than Section 14 of the Central Sales Tax Act. It must be remembered that the notification are exception notifications, but contain charging provisions. Because here also your Lordship will find the notification where two notifications of 1990, which I have mentioned here, have been saying about the rate of taxes. That rate of tax on barley will be 4% and at 1 point. So they are charging provisions. They are not exemption provisions. It must be remembered that notification not exception notification but contain charging. As such, onus to prove the malted barley does not fall within the food grain or cereal was on the revenue. They had failed to discharge the onus, but the tribunal and the High Court have concurrently found that malted barley is food grain or cereal for the purpose of 3 notifications for reasons that cannot be discarded as perverse. Then we also have referred to a few judgments where it has been said that skimmed milk powder, milk and skimmed milk powder are the same things. And then we got to Lordship, I have given 5 reasons at page 29.
Yes.
The following are the 5 principles relating to classification ought to be taken into consideration. Plain meaning to be given to the taxing provision. Burden to prove classification in a particular entry is always on the revenue. Any ambiguity has to be resolved in favor of the assessee. Resort to residuary entry is to be taken as a last measure, and the specific entry will override general entry. Now, how this section 14 of the CST Act to be read, I refer to a Calcutta judgment, Jindal India, which is serial number 40, explains it is not to be taxing, it is explains it not to be a taxing provision, but classifies different commodities under the same species under one entry. When different goods or commodities are listed together in the same subheading or subitem in section 14, does not mean that they are regarded as one and the same item. It is further stated that the intention of the legislature has been that various commodities mentioned in the same clauses in section 14 were to be regarded as different commodities. Therefore, going by the aforesaid principles and applying the same to the present case, it is amply clear that Robinson barley and Purity barley squarely falls under entry 16 of the rate notification. Principles governing inclusion of any goods under residuary entry is well settled. The resort to residuary entry be taken into the last measure. And they have referred to, and I'm also referring to Dunlop. The Dunlop says that the very basis of the reason for including an article under a residuary in order to charge higher duty is foreign to the proper determination of this kind. Court will loathe to say that it will not interfere. And here is the case that is the famous Ades said to not to consign it to the orphanage, but they have because they have a parentage. Now, burden to prove a particular fall under specific entry in the revenue is not on the assessor, then I have referred to a few cases. This is Union of India, Garwarian Island, then HPL, then Voltas. And the burden of proof is in the taxing authority to demonstrate that a particular class of goods or item in question is taxable in the manner claimed by the revenue, and that mere assertion in that regard is of no avail, which is lacking in this case. This principle. Dunlop says an article had by all standards a reasonable claim to be classified and enumerated in the item tariff schedule. It will be against the very principle to deny the parentage and consign it to the orphanage of the residue clause. And then I have said of entry 16, then I have relied on 3 more judgments, which is at page 31.
Yes.
Petitioner submit principle of law that specific entry should be override a general entry. In the case of Maharashtra, Mr. Bradma, the following CC, Silong and a day, it has been held that the resort can be made to residuary heading only when the liberal construction, the specific entry cannot cover the good in question. What I am submitting to your Lordship, that at a point of time, the Parliament has clearly stated in 1952 that cereals in all forms, that doesn't mean that there are 2 or 3 variety of cereal as we get it in paddy, but in all forms, whether whole or powder, includes the end product. Now that was the legislative interpretation given. And in order to go beyond this and to get into something else, there must be some reason somewhere. But I have shown to your Lordship that whenever such a situation arises, it is not the department, but the Government of India comes in giving the relief. Because the object is to give relief in case of essential goods. And not essential goods for the war or army, essential goods for the human. And therefore, my submission is that these questions have not been decided by the tribunal. First, I had said to your Lordship, and I'll repeat again, that a Orissa judgment, rightly or wrongly, consider Rajasthan to be binding on it. Now, if Rajasthan would have decided to go beyond Tungabhadra, which is a 5-judge bench, would have referred the matter to a larger bench. There is a judgment which I have quoted, it's from this court, that is Parija. Give me 1 minute, I'll just.
Pradeep Chandra Parija versus Pramod Chandra Patnaik.
I'm grateful.
Right. We have it here.
No, that judgment said that you have a right to disagree. Of a large judgment, you have a right to disagree.
Yeah.
But if you want to disagree, keep the judicial principles.
Correct.
Refer the matter to a larger
bench. Correct.
So therefore, I have also said that your Lordship can either direct the matter.
No, that kind of an exercise will be performed there, not here. All All right, sir. We'll just hear Mr. Mishra. Yes.
Your Lordship, my Lord and seniors are good. Your Lordship, I only realized
2007.
The judgment. Your
Correct.
Lordship,
He's aware of all your arguments. That's why such an elaborate written submission.
Your Lordship, in Satyanarayan Bhandar case.
Correct. It's here. It's here.
Not only Your Lordship, so far as the Rajasthan case is concerned, there are many cases also have been taken into consideration by this Honorable Court, Your Lordship. So far as Your Lordship, from the very beginning, Your Lordship, has this Honorable Court has distinguished all the cases. Karnataka, Your Lordship, Karnataka case, Your Lordship, also in Andhra Pradesh case, also in Rasoy Commercial Tech 51 STC, that has been distinguished, and Madras High Court case has been distinguished. Many, Your Lordship, my Lord and Senior has mentioned so far as that milk and skimmed milk, that has also been distinguished by this Honorable Court. And also so far as the Rajasthan roller floor mill, that has been also distinguished. And after making distinction of all these cases, Your Lordship, this Honorable Court has given the finding that both commodities are different commodities, and accordingly has decided in this bunch of cases, Your Lordship. So for particular issue, Your Lordship, this particular issue has already been decided. So Your Lordship, I can only rely that judgment because each and every judgment is there, Your Lordship.
All right. So we'll reserve orders. We'll reserve orders, sir. We have the benefit of your elaborate notes.
The first note was because with what I prepared in 1974.
Wow.
Your Lordship, when I have joined in the bar 2001, my Lord and Senior has argued the anti-tax, the constitutional validity of anti-tax.
Right.
On those days, we have in pen and paper, pen and notebook, and we have sat in there, and what is the Australian law, and all those laws we have learned from my Lord and Senior, you know. So I have got the occasion to argue against him. You know.
All right. Orders reserved, sir. Thank you so much. Thank you. Thank
you. Pardon, Your Lordship. Your Lordship, I'm from item number 40 weekly list. I'm for the petitioner. Your Lordship, actually the matter was not properly transferred. I was of the misconception that the matter is still in the hands of my learned senior, Mr. P.K. Ratha. But I didn't receive any NOC from him. So for that misconception, I could not come on time. Please kindly consider taking this matter to another date.
Tell us right now what it is.
Pardon?
You can tell us right now what it is.
Okay. Actually, Your Lordship, the matter is that the petitioner, he had taken loan from the bank, from the SBI, and mortgaged his property. So he has cleared the entire loan on 28th January 2013. The book balance was 0 on that date. However, he applied for the release of his documents on 9th October 2017. But the bank has not released the property yet.
All right. You say, you only want return of your documents.
Pardon?
Your prayer is only for return of your documents.
Your Lordship, I want to continue this because I want my papers back. My original papers are with the bank.
No, but what you have challenged is something else. Just come to page 7. That is what you are challenging. The prayer in your writ petition is something else.
Yes, Your Lordship. Actually,
they've advised you that your account is not eligible for settlement under the current OTS scheme.
Your Lordship, actually, after this, the bank had manually agreed to the scheme, and my client had...
If you withdraw this petition, that's a different cause of action then. As far as this petition is concerned, your only concern is about this letter dated 30th September saying you're not eligible for OTS. If something else has happened after that, you file a separate petition.
Your Lordship, I had cleared the dues in two
That's
payments.
a separate cause of action then. You have declared your dues after this letter, correct?
Yes.
After filing of the petition. Or the petitioner claims now, the counsel of the petitioner claims that notwithstanding the challenge the present petition to a letter dated 30th September 2012 of the State Bank of India, advising the petitioner that his account was not eligible for settlement under the bank's current OTS scheme, the petitioner has, during the pendency of the present petition, already cleared the dues of the bank and therefore is at present seeking the return of the property documents which were placed with the bank as security. Clearly, that is a separate cause of action that has arisen subsequent to the filing of the present petition. Consequently, while disposing of the present petition as having become academic, the court permits the petitioner to seek other appropriate remedies that may be available to the petitioner in accordance with law. The petition is disposed of. All right.